Any mention? Item number 1.
Okay. Well, pursuant to the last order, the officials of AI are here, man, to say.
One thing you see, Ruben, apart from this, where is your consolidated report? It's not ready.
No, it is, the reports are all submitted, my lord.
Your report?
The first report, the preliminary report was of Leh Dastur store, and the final report is of the Bhutan study, my lord.
So there's no consolidated report.
Consolidated report, I have not prepared, my lord.
I was inquiring about that. Yes, Dr. Mosika, you were saying?
My lord, what I've been told, my lord, because on the last occasion, we lots of recollect, while submitting the report, I pointed out that the cost of cutting hills was indicated in.
Oh, here, oh, yes. So,
my lord, now what appears that LiDAR survey that was done with keeping in mind the full-fledged, the larger airport, my lord, with a target of 3,700 meters of runway. And for the time being, because while doing the survey, they did a comprehensive survey, my lord. And the rest, my lord.
No, only one thing which firstly we would like some, clarity is, you see in this letter, dated 3rd September 2024, which is just a letter to the Chief Secretary, I think, which she had produced the last day, right? LiDAR report very technical for us, but there's one part, point number 5.
5, my lord.
So, my lord, what does this entail and what is the cost factor?
My lord, that is what the my lord, Mr. Gursev is General Manager Aero Planning, my lord, is from headquarters of.
Yes, you kindly enlighten the court.
Yeah, good morning.
Yes.
Actually, this survey was done keeping in mind the operation of Airbus 321, and for which 3,700 meters, about 3,700 meters of runway is required. So the comprehensive survey was done for the whole area LiDAR. And normally the airports, when we go for a full-fledged airport, we try to get that the operations can happen from both the sides, both ends of the runway. So after doing this LiDAR survey, we could get the exact cost and how much it would be required for hill cutting and all. So presently, suppose this is the runway. So presently it lands on 22 and departs in the opposite direction 04. If we want to bring an aircraft from this side, then all these hills need to be chopped off. So that is not environmentally friendly solution, plus not financially viable. So this is coming around 168 lakh crores. So this is simply ruled out.
That's the Ceylon side.
So we are not considering this case. This is only theoretically academic purposes. So this side only will be used. So presently already the approaches are made from this side.
Yes.
So if DGC agrees for bigger aircraft also, then these costs would be minimized. And on ground, some labeling work would be required, which may require about 100 crores rupees. Everything is again now dependent upon the regulator, the Director General of Civil Aviation, if they accept this proposal of 2,400.
The thing is that regarding this removal of this, approximately cuttings required 1.97 lakhs cubic meter. Earth filling required for extension and has ensured disposal of 10 lakh cubic meters. Okay. So 1.97 lakh cubic meter earth from which side? You have to excavate from the side where the planes are landing now.
The planes which are already landing from that side, suppose the runway is up to here.
Yes.
So when we extend the runway by 571 meters, so both side hillocks are there. They need to be cleared, and anything which is coming in these surfaces to protect an aircraft in flight. So this is coming around 12 lakhs and 2 lakhs filling. So that will be around 10 to 11 lakh cubic meter extra earth would be required.
And what will be the cost factor?
Cost factor for
that amount of yes,
cutting is
physical work
around 20 crores and plus transitional 51 crores, what the agency has calculated. So within 100 crores, it should be there.
Everything can be done.
Plus the disposal cost, plus the acquisition of land cost, and plus R&R, you have to rehabilitate people, so that would be separate. So yesterday there was a meeting with Chief Secretary and the Deputy CM. So we had explained the whole proposal to them, and what are the next steps would be like.
But I saw in the paper, if we can take cognizance of the paper, it's very alarming. There is a 8,000 crores been given.
8,000 crores.
No, that's not,
8,700 crores, right?
If there is a cutting from the other side, if there is no cutting required from the other side, that cost will not be required. What I am instructed to say, my lord, that the proposal which within 100 crore rupees and acquisition of about 16 acres of land,
22
that 16 acres is there,
16.
22 in altogether. The proposal is being put to cabinet in a day or so, because the presentation was made, and within 100 crore rupees, if we can have the bigger aircraft landing, so that cost is not astronomical, or cost is not very high. So it will become workable. In fact, I am told that matter will be placed before cabinet in a day or so.
100 crores. There should be a ceiling.
Yes,
So again, the DGCF, they say the aircraft which are landing from Tutu side, in this surface also there is some penetration of hills. So presently they have approved with keeping an aircraft higher above these obstacles. But if DGCA says no, you have to remove these obstacles, then that cost is 8,700 crores again, which will make it non-viable,
So
non-financial.
what will be the impact? I mean, does it impact air safety if, as it is now, they are operating like that?
You may be having this on its one chart.
I've given one chart.
So in chart, if you see, there are two like circles.
The
are
black
there.
and white one.
The
Yes.
lines. One is written AB and the other is written C.
Yes.
So AB is for a smaller aircraft and category C is for higher speed aircraft.
Yes.
So these are already promulgated and approved by DGCA. If DGCA says this is acceptable,
So this CAT C, this 12D approach is for larger aircraft.
to it should come. Provided again, the regulator should be on the same page. And so after the cabinet
For
approval,
regulator, they'll be on the same page only if there's no margin of error and the safety is maximum 100%. That's the only thing. That's to our understanding. And we are also concerned about that. That the safety aspect should be, shouldn't be 5% of any, even of any margin of error. So what will be, workable? That's the only thing. So what do you want to show us the diagram?
so this diagram, already the charts have been made and approved for bigger aircraft, for higher speed aircraft, category C. Now the runway, that in airspace, the charts are already prepared, but on ground, the runway length is to be increased. It need to be strengthened also.
Yes.
So it needs to be more so that it can take the weight of a bigger aircraft. So that will be the construction cost and all, land acquisition. But before all these steps, we have asked the state government that the proposal which has come from Chairman AI to the state government, they have to give us in principle approval. Then we will go to DGCA with concept design approval.
Okay.
That before actual acquisition and before actual construction, that DGCA, if it is the proposal is accepted to DGCA, or they may say you conduct the safety assessment or any other requirement which they say. So if the things are doable and this proposal is acceptable to DGCA, then only the actual acquisition of land and construction of things will be taken up. Presently, 2 airlines, and as I told you, the runway length is required, actual is more. But because there is a river on the other side, 04 extension side, so that is restricting us to 2,400 meters only runway. But Indigo Airlines and SpiceJet Airlines, they have said the 2,400 should be
Sufficient.
okay with them. And Airbus 321, they may come with some road penalty. Certain passengers they may not be able to take. So airlines is in support of this proposal. The state government also, AI also. So
What's the difference in A321 and
A321
319 is a small aircraft? Then A320 is a bit larger.
within A3 to A320, there are several models.
Right.
The smallest model is A320 Neo.
Right.
So that requires a lesser length, about 2,500 meters. As the aircraft is bigger and
Yes, no, I mean, this 321, it can land on 24 meters.
as per the calculations given by the International Civil Aviation Organization, ICAO, the length, calculated length theoretically is coming around 3,700 meters. With full load in the hot temperature, as we go up in elevation, the density of air becomes low, so they need more runway. And as the temperature increases, again the air becomes thin. So aircraft need longer and longer runway. So Airbus 321 may not be able to operate with full load on 2400 meters. And Indigo said they may bring it, but they need the strength of the runway, plus they may have to go for load penalties. And when any airlines is going for load penalties, too much of load penalties, it won't be commercially viable for them to bring. So Airbus 320 Neo and 737, they should be able to land at 2400. But before execution of anything, we need to take the concept design approval from the Director General Civil Aviation.
Yes, Mr. RK General, is
Yes,
that
my lord,
you say that this rework proposal under 100 crores is going to be put before the cabinet today?
No, tomorrow. Most likely, it is likely to be placed.
Who's
by-
preparing a proposal? You are
Proposal is given by the Airport Authority of
that will
India.
be workable within 100 crores.
That will be workable. The estimated cost is about 100 crore rupees. That will be placed before the cabinet.
That will include the land acquisition.
Land
and all
acquisition
aspects.
of 22
That will be
acres.
separate.
Or possibly, but the state government is positive, and state government may, because this is in greenfield project, we will have huge cost. Existing
So
airport
it will cost you
will be
a
huge
thousand
cost, and environmentally not advisable also for the state of Meghalaya. So what I am instructed to say that the state government is positive, my lord, your lordship may have it, and possibly we will accept the proposal of Airport Authority of India, and thereafter ball will be set rolling.
But only one aspect. My lord.
You think by the 1st of October something will come out?
Yes, my lord.
But only one thing I wanted to highlight, my lord.
Yes.
In the flight procedure, my lord, the black and white chart that is given,
Yes.
the lordship kindly sees it was approved on 15th of July 2021 by the DGCA. My lord, this is the path, my lord, how the flights are supposed to land in this airport. The circles and all those indicated, my lord.
Right.
And this was approved for both categories of aircrafts, my lord, for ATR as well as
Larger
Airbus
aircraft.
320.
Airbus 320,
Bigger
aircraft. Now, since they have only been operating ATR pursuant to this, my lord, now they have to go back to DGCA saying that we want to expand the runway and we want to operate 320 aircrafts also. So DGCA has to give the approval, my lord. So that is where the entire thing rests down. If DGCA says that yes, we have approved and you can go ahead with this, there is absolutely no problem, my lord. There is no earth cutting will be required. The cost as projected 100 crore rupees. Plus for airport expansion, your estimate
Around 500
around 500 crore they will be spent by airport authority, my lord. So that is within the possible limit,
Workable, yes.
workable limits, my lord. But only possible negative scenario can be, which we see, my lord, from the airport authority, if the DGCA says, my lord, because this has been approved with a gradient of 2.2 degrees,
3.2 degrees.
3.2 degree. When the flights are landing, my lord, ideal is 3.
Ideal is 3, but because of certain reasons, it can go up to 3.5 also.
Yes.
So it is within the tolerance, 3.2 degrees. So as such, there should not be any problem.
with the DGCA also, my lord.
But they may come up with any new thing which we may not be anticipating also.
DGCA is party here.
DGCA earlier was represented, my lord.
By whom?
I represented, my lord, at one point of time, many years back, my lord. But that was only when there was some delay in approving this chart, my lord.
What is proposed, my lord? Step one is that the proposal is with the state government. The state government is taking a decision. Most likely within a week, decision will be taken. Once decision is taken by state government, it will be communicated to Airport Authority of India. Airport Authority of India, after communication, it will take it to DGCA for approval. And once approval is granted by DGCA, we will take a step for expansion and acquisition of land.
Then groundwork will start.
So then, therefore, till that time, it is on paper, a real expense.
Right now, it's on the drawing board.
Yes, and then thereafter, so that is who will come up. DGCA participation will be required only when everything is cleared and placed before DGCA. At that point of time, we may have DGCA as a party. Yes.
Yes.
DGCA may have a party at this juncture also, my lord, instead of waiting, because this all approvals, it has to go to them finally.
Firstly, the cabinet will pass it.
Yes.
Then they will say, okay, fine, what earth cutting, we'll manage it in 100 crores.
Yes.
And airport authority put 500 crores. And the final thing is that once the proposals are through, then the GCA has to give the approval. So I think it's better if they are represented also, Dr. Mozika.
Yes.
It will ease the whole process.
Yes, yes.
What I would suggest, my lord, first the state government gives them approval, in principle approval, then they approach the DGCA, my lord. Then if there is any kind of hitch, maybe
Any issue, then at that stage,
that point of
DGCA may be implemented.
Yes, your name? Sorry, we didn't catch it.
I'm Dr. Gursevak Manish, General Manager Planning, AIE.
I could take down. Dr. Guru Savak Manish, Director Planning, Airport Authority of India.
General Manager.
General Manager, Airport Authority of India, is present in court today and has rendered his assistance in elaborating and explaining the exact requirements and plan of action that is necessary with regard to the enhancing the capacity of Shillong Airport. Stop. In his elaboration, Dr. Manish so-and-so has explained that as per it's called LIDAR,
LIDAR.
the LIDAR survey, a comprehensive we will see what is a comprehensive what will be the
The
word,
conservation area for the airport has
a
been
comprehensive not a survey,
survey area.
a survey of the entire airport area, including all the requirements, has been conducted. Stop. With regard to the earth cutting as required for extension of the runway by 571 meters, it has been stated that if the proposal is accepted and passed by the state government and by the regulatory authority, that the DGCA, the entire project, the same can be achieved within a cost of 100 crores.
on the part of state government.
Yeah?
That is cost.
That is cost on the part of state government, and on their part is 500.
Part of the
Your
state
lordship may leave that part, we have to work out the cost, but
No, we will put it down. Doesn't matter. It's just his
Estimate.
his estimate.
But what is being said that it has to be borne by state, probably we will get it from donor, we will get from some other agency, because saying in the judicial order that the state government has to bear, that will have some bearing in getting the fund also. So estimated cost is 100 crore rupees, that is that.
100 crores, estimate cost 100 crores,
Excluding the cost of
excluding the cost that will be borne by the Airport Authority of India in improvement, which will be,
it should be around 500.
which should
crores.
be to the tune of rupees 500 crores. Stop.
And this is excluding land acquisition and obstacle removals.
Yes.
If required.
No, we'll just leave it at that now, because let's come on the first. Is next paragraph. At this juncture, the Learned Advocate General has submitted that the proposal as has been put forward before this court today will be placed before the cabinet by tomorrow itself.
It will be placed before the
For the
cabinet,
cabinet, and a decision on the proposal
is likely to be taken
is like
within a week.
will likely be given within a week. Stop. What are your submissions, Dr. Mozika?
Well, my submission is to that extent. Once the state government gives the in principle approval, my lord, then the airport authority will approach the DGCA
Yeah.
for approval of the
Dr.
And
Mozika?
preparing all these documents, all we will be needing around 6 weeks. for all the documentation and all.
No, let them first sit on the proposal. Dr. Murzika submitted that once an in-principle approval has been obtained from the state government, then the airport authorities will go ahead with completing the other requirements.
From DGCA primarily.
Yes, by submitting the plans for the proposal before the GCA for other clearances. Stop. In this view, the matter poses matter on 1st October 2024 for further orders, and also to await the decision of the cabinet on the reworked proposal.
Light is there at the end of the tunnel now.
And also quote notes the assistance rendered by Dr. Sonso. Yes, in enlightening notes assistance rendered by Sonso. Right.
Hearing, item number 2.
But in this petition, the market regulation of the Government Automobile District Council is under challenge. So at the time of filing the application, the writ petition, my lord, was prior at page 15, my lord. Page 15. 1-5. Prior number 2. So it says, my lord,
Yes, sir. Yes, Mr. Siddiqui.
it says, my lord, set aside and quash the tender notice issued by the respondent number 2 dated 10/9/23.
Yes.
So even an application for interim order was placed before your lordship, but it was not considered. So now this prayer has become infructuous and I'm not pressing for it, my lord. So the tender has already been floated, about 300-400 people were allotted several markets. So if you notice the issue to them, my lord, it would take a very long time. So I'm not pressing this pressure and I will not interfere into their working in the market till 31st March.
But they have taken the trouble of supplying the list, I suppose.
Yes, they have given the thing. But now we have decided that it will not be of worth issuing notice to so many people.
How many markets are there?
About 400, I know.
Yes, Mr. Day. Mr. Day, how many markets are there?
More than 400, my lords. All over Garvins.
They're all tendered by the district council?
Yes.
Yes, my lord. And they are working. For last 6 months, they have been working in the market. Another 6 months remains. So if you go for issuing notice, it will take several months again.
So what do you want to do?
I don't want to press for this prayer, my lord. Let it be posted for hearing.
So you
And
don't
we will not
propose a
interfere
prayer,
into their work.
And then, but I think, look at the prayer now. There is an acquired Garvin district regulation of 54.
Yes.
Are the pleadings complete?
Yes.
The pleadings are complete.
Yes. So let it be
Yes, sir.
posted for hearing. my lord.
At the outset, Mr. A. Siddiqui has submitted that there is a constitutional council which soon submitted that prayer number 2 and number 3 as given in the writ petition will not be pressed for the time being, as it will involve issuance of notice to multiple entities and persons, and which will delay the entire process.
Yes.
He prays that the matter be taken up for hearing only in substantial ground. That is the challenge to the Garo Hills Autonomous District, in bracket market tax regulation 1970. Stop. Next paragraph, submission list in a council noted the prayers number 2 and 3 stand abandoned, and the court will, and the matter will go forward only on only to examine the legality of the
Regulation.
impugned regulation. Yes, list on
4 weeks.
list after
4 weeks. my lord.
4 weeks. The challenge is 1970 regulation. We can do it now also if you want. Yes.
Let it be on October 16th, my lord.
Why auspicious day?
No, it's not about auspicious day, my lord. They are disturbing the people who are collecting, my lord. They are also collecting tax from them also, the Nokmas.
My lord,
Who's
how
collecting
can we
tax?
They are
collect?
Nokmas, my lord. That is the instruction that I have received, my lord. That is why they want a long day.
Put that on affidavit.
I will put it on the affidavit.
If you pass on any orders you want, put on affidavit, yes.
Well, I will put it on affidavit, my lord.
Yeah, this the
My
matter-
submission may
this
also
the
be
matter
recorded, my lord.
After, yes, immediately after puja vacations.
Hello.
Item number 1.
Please mention it. Hearing.
My lord, this is against the order passed by CAT, my lord. I am praying for some accommodation today.
But every time now has been, when was it filed? Last year?
March.
Yeah. When?
After Puja.
Not ready matter to it.
No, this is only revision of the little, small matter.
After 2 weeks.
As you wish.
After Puja, Sunil comes.
As you
No
wish.
benches. On the request of Dr. Enmuska, Leonard TSGI, for some accommodation, let the matter appear after Puja vacations.
Bit much.
Item number 2.
Yes.
Lord, we
What do you
have
see in the additional affidavit?
My lord, additional affidavit we have filed. There, my lord, we have enclosed some of the photographs.
Where is that? 152.
If my lord will come to page number 10,
Number 10, yes.
yes, my lord, this is one of the plates, my lord, which is there in the Goralen road, my lord. My lord, this has been placed in such a way, my lord, this is above the road level, my lord, and this has been placed in a very dangerous manner, my lord. If this, if necessary steps is taken, my lord, to cure these defects, my lord. Otherwise, this is creating a lot of problem, my lord.
There is a very a small issue. What about the larger picture?
Larger issue, my lord, I have also enclosed the photograph, my lord, at page number 12. The traffic conditions, my lord, everywhere.
No congestion, yes.
Yes. And my lord, as per the last affidavit also, which was filed by the state, my lord, they were supposed to install those speed detection devices. I do not think, my lord, those cameras have been installed and then it has not been made operational, my lord.
Yeah, check up that. You can see Mary's that. Yes, I was wondering, what about these reckless driving by these two-wheelers?
My lord,
This is a persistent problem which even we face also.
my lord, this is this is the issue which we require time, my lord, because my lord, in the initial stage of the PIL, we have already made it clarify that we have limited manpower. However, on day-to-day basis, we are making the traffic department.
What
has
about
been-
fines? What about,
My lord, we are imposing fine to the violators, my lord. We are doing all the work. However, my lord, with this, which my friend has pointed regarding a speed detection, my lord, machine. Once this is, my lord, installed, this will also curb the traffic issue. Also,
You know, in
my
other states now where these smart city projects
My
are
lord.
going, even if you park a car wrongly, you'll get a summons,
my,
on your number, registered owners,
my lord, this.
WhatsApp or whatever number, and
My
the
lord,
picture
exactly.
of the infraction also is given.
My lord,
like
once-
how far you parked, like suppose wrong parking,
My lord.
and where. So that is then it goes to virtual court. Then you settle the fine.
True, my lord.
So
My lord,
those
once
things,
this,
whether you're thinking of any such measures.
My lord, once this
especially,
CCTV
forget about speeding, okay.
My lord.
Now this where he park all over the place, you see like Laban, like,
True,
all
my
these-
lord.
like these pictures are shown.
My lord, once the CCTV system is installed, which we are hoping, my lord, we have been instructed that a total of 389 where we were planning to install as per our report was in the previous round. We have already installed 368, which
Are they
are,
functional?
my lord, we are testing, my lord. The testing procedure is going on, my lord. So we are hoping that
Testing
once,
procedure meaning what?
my lord, these cameras are being tested right now, whether it will be feasible, my lord. We are doing the procedure. Once the testing is okay, my lord, it will be operational. So we are
How long
waiting.
will that take?
My lord, we have been informed that it will take another 3 months, my lord, because these have been installed in different locations, around 89 locations, my lord. And then we are hoping that once the CCTV cameras are installed regarding the wrong parking system and all those traffic, my lord, these violators,
Am I
drivers-
just the counsel petitioner?
No, my lord.
Yeah, you engage counsel.
Yes.
Okay.
So,
Yes.
so my lord, once these cameras, and so we are hopeful that those violators, those can be curbed, my lord. Those wrongful parking system, everything will be curbed.
Because nothing has changed, you see. Even this PIL has been filed since when, apart from initial spurt, and especially regarding parking on the side, now what have you done with workshops? They're parking cars on the road and repairing. Now what about right of way of, of vehicles outside civil hospital now on the junction to Hydri Park? I go every, they're constructing a drain, letting a pawn shop go there, not disturbing the pawn shop also. They just come yesterday. That's not a question of vendor side, it's a question of road safety.
My lord, true.
And my lord, the stretch from this Gurudwara towards St. Anthony College, my lord, the entire stretch is blocked by the two-wheelers, my lord, that is parked on the road.
Another thing is that even, outside the hospital, now outside the hospital, people even can't go inside because of these. It's clogged with, vehicles or with vendors on the side of the road, like Nazareth Hospital. There's so many complaints. It's become like now you have to address those issues immediately with regard to, these centers like hospitals, the ingress exit hospitals should be free from, from any.
True, my lord. True, my lord. We are also one of the victims to all this kind of
That's
wrongful
another
parking.
PIL spending, of course, vendors, but this thing is concerning road safety. Now suppose, a scooty goes, the vendor sitting there, cars coming here, hospital is there. The driver's scooty will land up in, just the other day, just to share with you, my own, one of my family members, my son, he had an accident scooty, with a bus. So, what are you going to do? Maybe he was speeding, maybe he was not, we don't know. But if curb is not there, that is what these children have a lot of energy. So that's the thing.
My lord, we are personally also, my lord, we are very much aware with lordship, what is falling from lordship.
But there must
My
be,
lord,
there must be very, stringent kind of stringent
My lord.
But if we haven't got the CCTVs on place, at least by the police on the street. Now, police should not have, lose the entire, what you call it, confidence. Just because there's some louts on the street who challenge authority. What's happening here? Rule of law is given a total go by.
And
Yeah, people have taken the law to themselves. They will challenge the police. What is this? If police have confidence and they have that kind of, what do you call it, that authority, they have to exert authority. And by impose fines.
my lord, enforcement
We are
is a
imposing fine, my lord. We are
It was a problem because the people, as if it's as if it's become like anarchy.
And my lord, this
Set up a shop anywhere, sell food in the middle of the road, start selling fish in the middle of the road. That's what's happening.
true, my lord. I will not deny to that lordship. It's
Then,
now, my lord, one more issue, my lord, in Police Bazaar, my lord, the internal road which goes towards the Hanuman box, my lord. First of all, that entire internal road is blocked by the hawkers, and on top of that, my lord, the cars are allowed to go through by that road, and this creates a lot of, my lord, problem for the people who, my lord, tourists, and for all other people, my lord, even children and all, my lord, and all the time, my lord, these vehicles, they keep on honking, and then, my lord, it creates a lot of problem.
see, we don't want to pass kind of strictures and make the entire exam station stand here. Everyone thinks that, okay, fine, High Court now is very calm and all. But that won't be the situation this after 2 weeks if this goes on. If the rule of law is not implemented, that is one thing.
lordship,
Is
whatever my friend has pointed out today and what is falling for lordship, my lord, these aspects, my lord, if lordship give us some time, we can come up with some development, or if this matter
Nothing's
can come after
happened.
Puju.
nothing's happened.
We are hopeful, my lord.
This matter was there since
December, my lord.
December.
yes. My brother saying also we have indicated how many times will the court indicate? If the police, they're saying that they have shortage manpower, even other manpower, if they don't have that authority, they should be given authority, should be given confidence. Any Tom, Dick, and Harry in the street can challenge the authority into whatever they want. They're saying about silencers, about those, what do you call it, those exhaust
pipe
sounds. You, in front of my house, although my house is a bit removed from the road, you can hear them with the racing right from Malki up to that point.
Especially at night time, my lord.
That's night time. They come, but that's the time they have. It's like the racing starts at 11:30 at night. See, this order of Supreme Police was issued on 16/2/2024. Okay, that's Annexure 13 to the affidavit file, page 46. This is the affidavit filed by the state, filed on 28 February 2024. The order is dated 16/2/2024. Now, after this order was issued by the Supreme Police, what has happened after this? This one, page 46. Just putting it, you heard of paper tigers, huh? Paper tiger is a tiger only in paper. You take down an additional affidavit have been filed by the petitioner pursuant to the order dated 6/9/2024, wherein photographs have been annexed with regard to iron plates that have not been installed properly, as also the intense traffic congestion in various parts of the town. Stop. Next paragraph. MSR Kolni, on behalf of state respondents, has not brought out anything new as to what measures have been taken by the state
My lord,
authorities.
so far as the iron plates,
But has repeated the submissions which have been made on earlier occasions with regard to the operationalization of the CCTV cameras, and today has further submitted that it would require 3 months more time to make the same functional. Stop. With regard to the orders have been issued by Stirling Police as far back as on 16. See what they've done. They were given that. That's 56. On 16/2/2024, which apparently had been issued pursuant to order dated 7/2/2024 from the court. The same, it appears, has not been implemented or acted upon in any manner. Next paragraph. This court takes a serious note of the situation that is continuing unabated. And directs that, let's go to, and yes, and to avoid and prevent any further orders, and to avoid any further orders whereby drastic action will be taken against officials concerned. It is expected that the district authorities take immediate steps on the issues flagged and noted by this court, especially with regard to obstruction to the movement of traffic, the right of way that should be maintained in PWD roads, and also that the entrance to public health institutions which pose hazards to the ingress and egress should be attended to immediately. Pose this case for further orders. One.
After Puja, my lord. We are
On
hopeful
14.
additional AG will be able to be present on that day.
Otherwise, becoming, a law, everything being the law under the own hand. We'll call this because further orders will call. If there's bench available, then they'll be answerable.
Yeah.
And we can't instill a confidence in the police, then
Item 3.
maybe we have to bring some,
It was your lordship. In this matter, we were required to file the rejoinder, my lord. I'm praying for a week's time, my lord.
to file what?
Rejoinder.
No, you say you wanted the instructions. What instructions do you have? But they survive here.
We would like to place the instruction on the form of rejoinder, my lord.
What instructions do you have?
My lord, we are yet to obtain it, my lord. We have already informed the client, my lord. They are required to give us some instruction on this. My lord, may I have it after Puja vacation.
The tree is not in the compound anymore.
No, my lord, it's
Then
been cut.
It's been cut already.
It was never in the compound of
It's
the
been, how many
petitioner.
trees were cut?
I think, my lord, there are about 4
You
to
should
5.
know how many trees.
I think, my lord, it was about 4 to 5 trees were cut, my lord.
4 to 5.
Six trees in total, my lord.
4 to 5 to 6 now.
6 total. 6 in
Then
total.
7. No.
6 in total, my lord.
Yes, Mr. Estapa today submits that instruction still yet to be received from the civil chief. He prays funds allowed 3 weeks for the time to obtain the same.
All right.
The trees already gone, then what remains now?
Item 04.
What is this?
My lords, may I submit this second observation report, my lord?
Yes. Lord, we are also filing status report.
Well and good, the measures you have done,
Yes,
but
my lord.
were they already put into place?
My
As you
lord,
plan?
kindly see the photographs. Page 7, my lord. Parlor sliding has been put in place. Kindly see.
This was done recently.
Yes, my lord.
This meeting was held on 10th September.
10 September was with regard to retaining wall. I'll just please. See, the 10 September meeting was with respect to retaining wall, because for future probably retaining wall. So McAfee was engaged on 10 September. But before that, your lordship kindly see the parlor sliding which is there at page 7 onwards.
I've given you a copy.
Yes, my lord. I have given a copy.
I just
to my
want to
friend.
No, fine. Mr. Alvin is fine. Measures on paper are fine, but what has it translated into real action on the
Yes, my
ground?
lord, that is visible from these photographs. That is why I was trying to place those photographs. Because in such kind of work, there will be some issues, my lord. I am not denying, but we have to take action promptly.
There has been some issues, but then to the extent of what has happened and I've seen those photographs, alarming.
Your lordship,
Depriving people of their, of
Yes, my
their
lord.
rice bowl.
yes, my lord, that their concern is justified and genuine, my lord, and we have tried to address through contractor on our own also, and also we have consulted the experts, because this kind of situation may arise in future when we will have heavy rain, my lord, because so far as the widening of the road is concerned, that is the need of the hour, my lord.
No, we're not saying development always comes at a price. The price shouldn't be so heavy that the
That
people they'll die paying it.
Yes, my
That's
lord,
all.
that is, that your lordship will kindly see photographs where parlor sliding has been done. where we have got those kind of runaway or sandbags have been placed. So those photographs, even plantation have also, if you also will see at page 13, plantations have also been carried out at page 13.
Plantations,
And grass crop and trees, what my friend is saying. So when we have this kind of situation, my lord, I understand.
plantation.
Yes, my lord.
What do you have
Also for page 13, my lord, because if you also will see my government in that regard, I understand, your lord.
I understand this to stop landslide in future.
Yes,
I'm talking about to arrest the immediate, the damage is being caused.
Yes, your lord. Page 3 where the
Where in your affidavit have you said?
Yes, your lord.
Where you said that, we have arrested the landslide, we have arrested the landslip.
Yes,
now nothing further is happening, and then whatever's happened, we are trying to clean it.
Yes, your lord. We'll see page 2 onwards, my lord. Page 2, paragraph 2.
Yes.
The alignment of Joai bypass runs parallel to Maitandu River for approximately 1.850 km. Proximity to the river presents unique challenge, particularly during monsoon season, since region is one of the area with heavy rain, coupled with unpredicted cyclonic event. When cyclone Remal, which hit the region in the last week of May 2, 2024 and have caused significant disruption. Cyclonic rain and heavy downpour that followed the day after led to extensive silting of Maitandu River, which further complicated construction effort and raised concern over environmental impact and safety. To mitigate the challenge posed by the monsoon and environmental factors, several preventive measures have been implemented, providing sandbags, pala sliding in many locations to prevent the sliding of downhill slope, which will otherwise flow down to the river Maitandu, thereby preventing the silting of the river. And your lordship will see the various works up to second week of September 2024. These pala sliding have been carried out.
Let me ask the petitioner, has any improvement work been done?
My lord, I will answer to that. I'll just assess my lord.
And then
in that.
next page also.
There are two reports. I went on Sunday, my lord. I went myself and I've collected a few photographs. My lord, may I have a look at this?
If my friend would have taken my engineers also along with them, and they
My
would,
lord, because if I go with the engineer,
they were trying to contact the learned amicus, so that at least we will have the clarity. If there are some issues, we could have called the
Yes, no, that will.
Yes,
settle it. Okay.
My
So
lord,
this
yes.
is just we are concerned. But last time we took it up.
Yes, my lord.
Yes, my lord. And your lordship, let me place it, then I will show what action we have taken. Page 3, my lord. Tree plantation along with the slope is also being carried out, which will further enhance the stability of soil. The natural barrier not only helps in soil retention but also contributes to overall environment restoration of the area. Tree saplings that are being planted are so and so, my lord. Then 50% of tree plantation along with alignment road will have to be undertaken only when this carriageway is prepared, and assurance is being given that tree plantation will be carried out when carriageway is prepared. Removal of loose soil and debris. Loose soil and debris in many locations are being cleared and dumped in designated dumping ground. Photographs annex C1 to C6. Although in some locations the earth was not cleared due to intermittent rain, but now since rainy season is almost over, with onset of the dry weather, remaining excavated earth, soil and store border, which will not be used for ongoing road construction, will be completely removed and dumped in the designated dumping ground. Copy of NOC of the dumping ground is attached from C7 to C12. In some locations, soil with stone and boulder will be utilized for granular subbase for pavement, for backfill in the abutments of bridge, and retaining wall being conducted as a cushioning layer in the box culvert being constructed. Photographs are so and so. In some locations, to prevent rainwater to flow directly downhill, barrier is provided and cross profile of the road is being made, sloping to the uphill side so that runoff rainwater flow through the side drain to the nearest cross drainage constructed for discharge. Photographs. Now, permanent slope protection measures which are incorporated into DPR, these measures are crucial to ensure long-term stability in the area. Permanent slope protection measures or protection work like retaining wall are being constructed along with alignment of the bypass. Construction of these protective measures is underway in various stretches along with road totaling a length of 208 meter. Photograph is attached. On 10 September 2024, a meeting was initiated by Chief Engineer in his office and with the concerned engineers, with the Dharan Company, EPC contractor and representative of McAfee, a company stabilizing and slope stabilization. The objective of meeting called by Chief Engineer Shillong was to highlight the various mitigation measures that could be adopted apart from permanent structure like retaining wall, which was provisioned in the DPR for ensuring slope stability, especially on the downhill slope on the ongoing construction of Joy bypass, where a presentation of various mitigation measures were presented by Market Ferry Company. Chief Engineer has also to furnish the rate per square kilometer so that consolidation unit for slope protection for mulching and net method for slope stabilization which could be implemented. Due to cyclone Remel and subsequent heavy rainfall on the days that followed, the paddy field in the lower valley had been subjected to sand debris flowing downhill. The office of Jawai had tried to identify the owner of paddy field so that steps could be taken to remove the debris. An informal meeting was held by paddy field owners before conducting joint inspection on 29 July. A letter was received from paddy field owners about their demand. A reply by the office to the paddy field owners assuring that maximum help possible for executive engineer. Photocopy of the letter attached is as detailed in the joint inspection with paddy field owner. The old stream channel has to be dug to prevent recurrence of deposit of debris in paddy field, since the stream is flowing through the paddy field. Cause the stream had no channel due to years of siltation, encroachment and operation of stone and sand quarry adjacent to stream, which was closed down by district administration. Since then, water of this stream flows through the paddy field, and this has caused the maximum deposit of debris in the paddy field. Debris in paddy field can be removed in the winter months when the field are dry and hard. Social impact assessment was not conducted by the then executive engineer, since the acquisition of land for national highway is exempted under social impact assessment as per a manual of guidelines of land acquisition for national highway under National Highway Act. Abstract of pages are placed below. Environment impact assessment was not conducted by PWD. Ministry of Road Transport and Highway never insisted on EIA study when DPR was submitted, since Ministry of Environment and Forest had passed notification on exemption on 20.
No, one thing, yes, exempted is fine.
Yes.
But I mean to mitigate the damage, that's all.
Yes.
That's up to the departments executing the project. That's
Yes, my lord.
We're not saying that if you don't require a permit, you can go, you can just do whatever you
Damage.
That cannot be, cannot be the argument.
Yes, my lord. What I want
One thing, you've been,
Yes, my
like, what we'll do is,
Yes. My lord, may.
you see, the thing is that
Yes.
this is quite detailed. A lot of, you go one day,
Yes, my lord.
please
you go
inform
along
the
with
paddy field owners, the engineers.
yes, and then with the engineers, and you just
Inspect
now
and
you
give us
record the status report,
My lord, my lord.
and also yours.
Yes.
But then this status report is a bit detailed, and whether then you can make impartial kind of observation.
My lord,
that
You
this
understand?
thing can
My
be-
guess is here to assist the court.
Yes, my lord. My lord, this is what I have done myself. This one is a
So
very.
these photographs, we've seen them before.
Yes.
Even the ones they see the deposition of this
Yes.
debris that is there.
Yes.
And then you go one day, let me explain to you. When
Yes.
you go to an entire length.
Yes. And
You
also.
take down
Yes.
a status report dated 24th September. A status report has been filed today by the state respondents, indicating the steps that have been taken to mitigate the damage caused to the Mintu River due to the construction of Joy bypass. The same is taken on record. Stop. Observation reports also submitted by the amicus curiae to the itself, which is also taken on record. Stop. Next paragraph. Little Advocate General, while addressing the court, has referred to the status report and also to the photographs annexed thereto to show that adequate steps have now been put in place to arrest any further damage being caused. Stop. In this view of the matter, this court considers necessary to request the amicus to make a personal visit to be accompanied by some affected landowners in the vicinity, stroke that is paddy field, vicinity is paddy fields, and also the concerned officials from the
PWD, executive
from
engineer.
the PWD roads,
Yes.
National Highway, as also from the district administration.
My lord, my lord.
Stop. Convenient date may be worked out by the amicus, but it's expected that same should be completed before 19th October, 18th October.
And my lord, that yes, my lord, we will work out that. One more thing that I want to point it out, my lord. If my lord will be pleased to see page 6 of the report that I've submitted, my lord. Now, why I'm saying this is I'm sharing the concern is, my lord, lest if no interim orders comes from here, lest we see the Mintudu turning to the fate of like a river.
Stop that. That's why you go into your report and make
Yes,
details
yeah.
where you can.
Yes.
That's the thing. Yes.
My lord.
List the matter on. We listed on 21st October.
21st October, my lord.
Hello. By now 13 is over.
Any mention?
My lord,
Yes.
item 29, my lord. On behalf of Ms. Sandy Sulaiman, he's stating this
29,
matter.
yes. Karimul Islam.
My lord,
Who is the petitioner?
Sir Muzika, my lord, senior counsel.
You
Sir
informed
Muzika is
him?
leading. I'll inform him, madam. Probably
You
he's
will or
outside.
you have?
The juniors are around, I don't know. They must be outside, I believe. I'll inform them, my lord.
You're there in the matter?
Item 1.
No, he's standing up. I thought you're in the matter. 2 weeks, okay. It will be requirement of the AAG. Yes. Yes.
May it please, Lordship. Your Lordship, I beg to mention item number 26. Your Lordship, on behalf of the conducting council, Your Lordship, due to some personal difficulties, I pray if this matter could be taken up after the puja vacation.
26, what's the matter about?
Your Lordship, this pertaining to that electrocution matter, Your Lordship.
No?
It's pertaining to the electrocution matter.
Okay.
No objection, Lord.
After vacation, yes.
Highly obliged. Possible.
May it please your lordship. So I beg to mention item number 27. This matter may kindly be taken up after 2 weeks, madam.
Where is Mr. Sen?
We need to get instructions on the additional affidavit filed by the respondent petitioner. madam.
After vacation, yes. Yes, on the request of also. Yes.
May it please the court, I beg to mention item number 30, your lordship.
Herefore, the respondent,
The respondent number
no
1.
objection also. How long? Mr. Nompure, you're there? For whom? For the petitioner?
No.
For the petition. Item number?
This is 30.
30.
Lordship, 30.
2 weeks, yes.
Deep Lordship.
I was responding for it.
In 30?
Yes.
Yes.
Obliged.
Supplementary list, item number 1.
What is this, Mr. Day?
My lord, there is a contempt where my lord will recollect that Bhulaganj, those people where my lord has.
11 got training licenses.
No, my lord.
Why?
My lord, they have asked, as per the order of this honorable court, my lord, we have made a representation. We have filled up the forms and all. Even the receipt copy was also not given to us, my lord. They said that no, we'll process the file. Now, my lord, it's going to be 1 year, my lord. In October, it is going to be 1 year. They have not given us, my lord. We have no other option, my lord. It appears, my lord, they are the most unfortunate people in the state of Meghalaya.
Then we'll have to take some action from the court itself.
My lord, may kindly come to page 42, my lord. Para 1, my lord. All the petitioner in this petition shall apply individually for renewal of their respective training license by submitting their application before the officer of the secretary to the executive committee within 4 weeks from the date of the order. On receipt of the said application, the respondent number 2 shall dispose of the same within a period of 8 weeks. Thereafter, it is also provided that the respondent number 2 in this exercise shall nominate and authorize the special. So we have done, my lord. And then, my lord, may I kindly see page 52, my lord. Annexure 7 in series. 52.
Yes.
We make a representation also, my lord.
Oh, 1 year, nearly 1 year gone.
We submitted the form within 4 weeks, my lord. We was asked to appear before them. We have appeared, my lord. Even then, my lord, till date, my lord. It's very
Take down,
unfortunate.
firmness is the issue notice. This matter concerns the alleged violation of the orders of this court dated 4/10.
Yes, ma'am.
2023. Passed in a series of writ petitions. Stop. Steps to be taken by SAD within 3 days, less after 2 weeks.
Anyways. Item number 1 to 43 will carry the same order. 43.
44.
What is this, Mr. Nath?
Maybe it's your lordship. Before my lordship, if this matter can be taken up, then the board lordship. This matter is being led by Learner Advocate General Lordship. He's on legs before.
Yes. After some time, Mr. Nath, yes.
Highly obliged.
Yes.
45. 45.
Lordship 44 to 50 is connected lordship.
You say that? Okay, 50.
My apologies.
$51.
But this matter pertains to cancellation of patta, my lord, by the same of cancellation, my lord. Lord, the property in question, my lord, is an ancestral property, my lord. And my lord, in 2022, Prior to that, my lord, there've been some my lord, litigation between the parties, and thereafter, my lord,
They are within the same family.
yes, my lord, I'll just take your lordships to the family tree. At page 36, my lord, kindly have the family tree. Page 36 and extra 3, my lord. So, my lord, the property belonged to Kamali Devi Sharaf, my lord.
Who?
Kamali Devi Sharaf at the top.
Yes.
My lord, there were two sons. So we are concerned with the right side, my lord. We are concerned with Mahavir Prasad Sharaf on the right side. After her demise, my lord, there was a partition and half the property went to the right side. Now, who's before your lordships is, my lord, on the right side. Third line at the bottom, my lord, Amit Sharaf, Samit Sharaf, my lord, from one line, from the line of Om Prakash, and Binit Sharaf from the line of Binod Kumar.
What are the middle one? Kailash Chandra?
Yes, my lord. Kailash Chandra, my lord, is the one who objected before the Same of Malay, and on whose behest, my lord, the patta was cancelled, the joint patta.
So, joint patta was in the name of whom?
Of Amit Sharaf, Samit Sharaf, Kailash Chandra, and Binit Sharaf, my lord.
Okay, it was in their
Joint
names.
Yes, my lord.
Then what
So
happened?
he filed an objection, my lord. Now during pendency,
Objection on what ground?
an application for cancellation of the patta in the name of the petitioners, my lord, saying that this property, yes, my lord, saying that this property, in terms of arbitration proceedings, my lord, award has gone in his favor. That was his contention.
Arbitration award?
Yes, my lord. There was a private arbitration, my lord, set up by Kailash Chandra himself, and on the basis of that award, he presented before this Same of Malay, and Same of Malay has cancelled the patta.
But were you
without hearing us?
Arbitration proceedings?
No, my lord. Now, pursuant to the award, no, we were parties, my lord.
Then?
But pursuant to that, for execution of the award, he files a suit, my lord, in Guwahati, Kailash Chandra, and the suit was dismissed, saying that
Guwahati?
yes, my lord, because the properties, my lord, are there in Guwahati as well as in Shillong, my lord. So this is
arbitration covered all its properties.
Yes, my lord. So he filed a suit for execution of the award, and that suit was dismissed, saying that no, the arbitration is not binding because it's not registered under the Registration Act. He files an appeal, that is also dismissed. Now that was not disclosed to the Same of Malay. I'll just show your lordships. Your lordships.
Arbitration won't be like a family settlement.
No, my lord.
Let's see.
Yes, my lord. Lord, kindly have the impugned order first at page 123. Now, before the impugned order, I'll just take your lordships to the complaint, because the dates will be important, my lord. Lord, kindly have page 105. That is the patta, my lord. And extra 13.
It's a shop or what is it?
It's a house, my lord.
It's a house.
Dwelling house. So this is page 10.
Barabazar.
Umsausen, my lord.
Okay.
So, my lord, this is page 105. This is the patta of 2022. If your lordships kindly see, it's in the name of Amit Sharaf, Samit Sharaf, Vanit Sharaf, and Kailash Chandra Sharaf. So Kailash Chandra is the uncle, and the rest three are the nephews. So this is the, my lord, patta. Now at page 108, my lord, he files an objection, despite his own name being in the patta. That is Kailash Chandra Sharaf.
Yes.
So upon this objection being filed at page 108, my lord, the Same had, my lord, issued notice to the parties to appear before the Same. However, during the inquiry, the complainant himself was not my lord, present because of his ill health. And during the proceedings, my lord, at page my lord, 121, the complainant passed away. The objector, Kailash Chandra. This is the Hindi version, my lord. Next page is the English version at page 122. So he passed away on 23rd of November 2023.
Okay.
Now, my lord, after the objector has passed away,
Where's the arbitration agreement?
my lord,
What? Where's the arbitration award?
I'll take your lordships to that. Before that, my lord, can you have page 123? This is the impugned order, my lord,
Yes.
cancelling the dated 11th of March 2024. Now, this 11th of March 2024 was served to us upon us only on 12th of September, my lord. Page 25, 125 is the receiving, my lord. Now, this order is based on the arbitral award.
Yes.
Now, I'll take your lordship to the arbitral award, my lord.
So you say that you would not heard, that's all.
Yes, my lord. And after the person has died, yes, my lord, notice will be issued.
Mr. Nobri, General Counsel, petitioner issue notice, returnable in 3 weeks. Steps to be taken by section AD within 3 days. Yes, upon your.
I have a stay application, my lord. My lord,
Stay pata.
no, my lord, what has happened is, in between, the patta has been issued in the name of the wife of Kailash Chandra, my lord, the ancestral property, and they are trying to sell the land. My only prayer is, during pendency of this writ petition, my lord, the land shall not be disposed of, my lord. The limited prayer, my lord.
Where's the other side? No one's there. You haven't served Immilim.
Similarly, my lord, we have served upon the office, my lord. They yet
Yes, as the matter concerns the cancellation of the pata, it is provided that the next date status quo shall be maintained by the parties.
Lord, property shall not be disposed of. That may be indicated. Property should not be disposed of.
And the property not be encumbered in any matter.
Deeply.
52.
Please, Your Lordships. Let's, this writ petition, my lords, basically challenges a certain tender process, my lords, with regard to, my lords, the reinstallation of pumps for the Shillong PHE. Now, very interestingly, my lords, the terms of the tender were the lowest tender is to get the tender, my lords. There's no
The
dispute.
rose tender was?
The award is to be made in favor of the lowest tender, my lords, L1.
Okay.
Now, my lords, I am L3 before your lordships. The interesting fact in this matter is, my lords, that the price difference between, my lords, L1 and L3 is, my lords, 28 rupees and 928 rupees in a contract which is worth roughly about 16 crores. Now, why we are before your lordships is, my lords, in arriving at the time of the price discovery, my lords, what our cases before your lordships is, and it was before the department and we represented before the department, that the price discovery has to be made on the basis of, my lords, what would be the cost of operating this particular system also, my lords, over a period of time. What has happened here is, my lords, during the price discovery, they have not taken into consideration the fact that, my lords, the power that would be consumed for operating the pumps of L1, my lords, which otherwise, my lords, L3, we say that it would be at a much lower cost because we are supplying the same set of pumps which are existing today, rather than a new set of pumps, my lords, which L1 has now proposed to submit. Now, I am, my lords, here before your lordships on a very limited issue at the moment. I would only pray, my lords, let the state file an affidavit as to what was the process adopted by them for the purposes of this price discovery, where, my lords, I am put at L3 and L1 has been awarded the contract. As your lordships would have noted, my lords, the difference is 28 rupees and 928 rupees. That's the difference between, well, it's L1, L2, and L3.
So even then, Mr. Paul, how can we sit and appeal over the finding the tender committee?
No, I'm not on that, my lords. What I'm saying is,
technical matter. How will we to this?
No. What I'm saying is, my lords, that there was no appropriate price discovery, which is why, my lords, at this stage I'm only praying. Let them file an affidavit saying that this is the procedure we have adopted. Now, if it is in terms of the tender, my lords, I would not have any case before your lordships.
Even then, yes.
Yes, your lordship will file. Because otherwise, if your lordship will see the representation, my friend is saying that the tender is lesser in amount to the extent of 5,000 rupees.
1,928 rupees.
If I read it, it is somewhere 5,000.
Yeah, I made the calculation. My lords, I've done the
5,000
calculation.
rupees. It says that lowest bidder is around 5,000 rupees. So now 190, I don't know from where.
Because my lords, we've given the table at paragraph 6. It comes to, my lords, the difference between L1 and L2 is 28 rupees. And between L1 and L3 is 928 rupees.
And petitioner, my lord, 5,000 rupees.
No, no.
We had a case recently where the difference was 1 rupee.
1 rupees 29 paisa.
Whatever,
29. That is the.
Yes, I heard Mr. K. Paul Leonard, senior counsel assistant by so-and-so. If you notice, Mr. A. Kumar Leonard, Advocate General is present with so-and-so, except on behalf of respondents number 1 and 2. Both respondents 3 and 4. This is the matter after 2 weeks for instructions to affidavits.
Well, we'll have to take steps on R4. R4 is the
R3 and R4, 2 of them.
balance.
That we've said.
Grateful.
Well, may I only pray that your lordships hear us on any interim issue after they file an affidavit?
That you can make a case.
If that falls, my lord, because otherwise that
That will come with instructions first, then you,
balance.
that's how we plan.
And it's a important public.
No, no, I am not pressing. Because I understand, Malaj. I will not press that matter.
Yes.
Second call,
Alright.
item 44.
What is this, Mr. Nath?
This is an issue relating to.
Service, my lord. Well, here, the petitioner is serving for last 12 years, my lord, on ad hoc basis.
20 years.
And there,
20 years.
12 years, my lord, now.
12 years.
Now. My lord, their name also has been recommended for regularization. But in the meantime, my lord, an advertisement has been floated to conduct an interview. And in regard to the post held by the petitioner, and there are so many other employees or ad hoc employees
Where's
also.
the
my lord.
advertisement?
Advertisement is in page 36, my lord.
Page?
36.
This was the post that you're occupying right now.
That cover under the head serial number 32, 33, 34, my lord. Chowkidar is there. I'm holding the post of Chowkidar, my lord. It is under the head of 32. Serial number 32 under the head of combined grade 4.
You are
Chowkidar, my lord.
Chanda. Ningchira.
Yes, thank you.
Where's Ningchira here?
No, it's my name is in the page number. Page number 23, serial number 80, my lord. My name is there.
Why is it 36?
36 is the advertisement, my lord. The advertisement has been floated for the post of grade 4 post, my lord. And I'm in the grade 4 post.
I don't understand. Upon 22, page 23, is it?
Page 23, my name is there, where the names
Your
which
point
have
is
been,
ad hoc, okay.
which have been submitted to the higher authority for the purpose of the consideration for it.
Page 23? Who is your name?
23, my name is there in 80, my lord.
18?
80, serial number 80. Page
Page 23?
Page 23, serial number 80, my lord.
There is something different here. Are you sure you read with petition? Absolutely, it's not matching.
Yes, ma'am.
This is WPC number 330.
Yes. Nanchira, my lord, yes.
Where is the page 23 item? Page 22, statement showing upon employment ad hoc basis. Okay. Then page 23, serial number ends at 15. Who is the name of the petitioner?
Petitioner Nanchira, my lord.
Nancy Aring.
Nancy B. Marak.
Yes. Is it there? No. Page 23, name's not here.
That's where page 23, the recommendation has been made, my lord, list of the ad hoc employees.
So kindly see my file and if you want to clarify things.
Which name?
See page 23 of the court's file. Where the Ninkira?
Not there in my file, I think.
See, Mr. Nath, when you're making, anyway, go to the right.
It is 30 in the. 30 serial number? 80. It's 40.
You have to correct it then. Page number 80, page number
40, my lord.
The whole.
Forty. Till number
80, my lord.
80.
80.
40. Okay, Nankira, right. Page 41.
I'm sorry, my lord, I'll correct it, my lord.
Correct your own copy. You correct together, like, should match the court copy. That's all. Yes. So you were, that your name was forwarded. You were officiating. Statement you appointed ad hoc basis, right? What happened after that?
Thereafter, my lord, that name for, and also, my lord, recommended for regularization, my lord. Here, my lord, Annexure 5.
By whom? Annexure 5?
By the Annexure 5, my lord.
Annexure 5? Annexure 5 here is a statement showing appointment of employees. Type copy. Page 32.
There were 3 copies.
What is Annexure 5? What is Annexure 5? You're totally confusing the court. It's not just one thing. You reconcile your petition, we'll have it tomorrow.
It's better, my lord, because
You just examine it. Let your junior colleague just sit and examine it. Yes, this matters tomorrow.
Tomorrow, my lord.
Daily list, item number 1.
What's the matter about?
This is a contract matter, my lord. We have filed an affidavit to raise preliminary objection as regards the maintainability. Our case is, my lord, the tender was issued from Agartala, my lord. The cancellation was done from Agartala. The entire cause of action arose in Agartala, my lord.
Yes.
My lord. My lord, if I may just point out para 3 of my affidavit, my lord.
1 second. Yes.
That at the outset, the deponent state the instant writ petition is not maintainable before this honorable court. As such, no cause of action wholly or in part has arisen within the territorial jurisdiction of this honorable court. In the instant case, the online NIT was issued by the Office of Executive Engineer, Border Fencing Division so-and-so, CPWD Agartala, for the work so-and-so. The work was to be executed in Udaipur sector in Tripura. The performance bank guarantee was submitted by the petitioner in favor of the executive engineer so-and-so Tripura Agartala. The letter dated 27/2/21 to Bank of Baroda for forfeiting the petitioner's performance bank guarantee was issued by the executive engineer so-and-so CPWD Agartala. The letter dated 19/9/23 intimating that the petitioner is not entitled to release of forfeited performance bank guarantee under the Vivad Se Vivad scheme, as the petitioner did not fulfill the criteria laid down under the said scheme was issued by the executive engineer so-and-so Agartala. As such, no cause of action either wholly or in part has arisen within the territorial limits of this honorable court, and as such, the instant writ petition is not maintainable before this honorable court. It is further pertinent to mention here that earlier, when the performance bank guarantee was forfeited, the petitioner has approached the Honorable High Court of Tripura by way of WPC number so-and-so, and the same was disposed of by the order dated.
So it's already, once it's already gone to court.
My lord.
My lord. Hello, in this case, I have also filed the rejoinder at paragraph number 2.
Why are you forum hunting then?
My lord, here, actually, I am not before your lordship. My grievance is the cancellation of forfeiture of the claim, refund claim of the performance guarantee amount, not the forfeiture of the contract, nor the maintainability of the contract, nor the maintainability of the execution of the contract. Here, actually, the issues before your lordship is, I am entitled for the Vishwas scheme has been implemented by the central government within the through of the territories of India. And being a MSME enterprise, and I am eligible for the refund of the performance guarantee amount because I have withdrawn my work from the bidding before execution of the agreement. I have not signed the agreement. Whenever the amount I deposited on the basis of the work order issue, and I deposit the security deposit as a being performance guarantee. Subsequently, during the continuation of the COVID-19 pandemic situation, it is not possible to execute the work. So immediately I withdraw. And one my supervisor also abducted by miscreants, that's also another hurdle for me. So immediately before execution of the agreement, I withdraw from this bidding. And accordingly, my bidding has been, my amount has been forfeited. Performance guarantee has been forfeited. Deal that I have no objection on that, but whatever I have before
Whatever
that,
it is, Mr. Mishra, you know? Your name, you are Mr.
Sahu.
Sahu, Mr. Sahu, sorry. Mr. Sahu, everything has emanated from the contract itself executed in Tripura. And
Yes.
as per, how will this court have jurisdiction?
Yes,
on one
madam.
part of it?
It is my responsibility to
Satisfy this court. How?
satisfy the court.
How
Yes,
is
yes.
the cause of action?
Actually,
then?
sir,
Suppose dispute arose with other parts of the contract. Do you mean we'll go to Agartala?
yes, that
You won't go.
that is forfeit. I have no objection on that.
Suppose you had entered into the contract, you had executed. So midway, some matters come up, and will you come to run to Shillong?
Yes. No, I have already in the previous
You've already
occasion.
gone to the Tripura High Court. You already said
Yes, I have.
representation.
When my contract was forfeited, agreement was
You filed representation.
Yes, I
What happened
did.
to
I am not challenging that. That is what is
Does not challenge you. You can't write your 2 feet or 2
Yes,
goats.
my lord, I am satisfied, your lordship. Actually, I am a MSME entrepreneur from Shillong. My place of business is principal place of business Shillong. I executed the bank guarantee from Shillong, and I uploaded the portal from Shillong, and the bank guarantee was vacated by this respondent from Shillong, and the Vishwas Vibad scheme, it is has all over India territory implications. So whenever this part is completely at Shillong, so I have the jurisdiction. This honorable court is a territorial jurisdiction to decide the case as per the facts and circumstances of the case. So I have also annexed the documents. There is no dispute by land friend. There is no dispute because bank guarantee has been created from Shillong, and that is vacated by the other party from Shillong.
Bank guarantee can be created from anywhere where you have a
Yes,
large
that can-
amount of deposit. That's all.
Yes,
I can even raise a bank guarantee from Punjab. Suppose you're doing some contract.
It can be done, but I have not done that.
Punjab Haryana High Court.
No. Actually, my main place of business is Shillong, and actually, Article 226 of Clause 2.
Of course.
When is a partial cause of action is happen during the territory of this area, so that can be the jurisdiction is there. So in this case, by law, whenever a partial education, when I created the bank guarantee from Shillong and vacated by bank guarantee from Shillong, this is a partial cause of action because there is no specific definition of cause of action in Article 226 or in the Constitution or any other CPC also there is no. So keeping the facts and circumstances of the case, the cause of action is to be considered for disposal of the case, my lord. So in this case also, there is a partial cause of action here. And my consideration is here only to refund my
guarantee.
personal gain, nothing more than that.
Yeah.
So under these circumstances, this scheme has all India impact.
Yeah.
Union of India has passed Ministry of Finance to the Department of Expenditure. They have circulated this scheme, Vishwas se Vivad scheme, in February 2023. And I am referring this scheme and asking my refund claim to the opposite party, who is there denied.
Yes. Yes.
This is my grievance, my lord.
Only two aspects, my lord.
So, for this purpose,
draw lots of attention to the order passed by Tripura High Court of Lordships at page 109 of the writ petition, my lord.
my lord, I have also some
Authorities.
Supreme Court decisions in this case,
Yes.
that division bench, full bench, and some High Court cases also there.
You're seeking your refund of performance
Yes,
and
sir.
guarantee now.
Nothing more than that.
And moreover, my lord, the impugned order, page 118, my lord.
Yes. What happened to your representation? Rejected?
My lord, page 118 is the order, my lord.
Yes.
My lord, our case is, my lord, the entire cause of action. No part of cause of action, only because he is a resident of, the petitioner is a resident of Shillong, my lord. That will not give a jurisdiction, my lord. And secondly, only because the bank guarantee was drawn on a bank from Shillong, my lord. That will not give a cause of
No,
jurisdiction.
one aspect also of this order dated page 130 passed by Tripura High Court, that aspect's been gone into also. It says that you should inform the court if whatever security issues, then you file your representation before the authorities with regard to refund of your performance bank guarantee. You filed it, and the same was rejected by this order 19/9/2023. So it's for you to revert back to the same court. We'll pass orders, yes. What is this decision? Yes. It's a continuing process. If you're not gone there, maybe.
Actually, I am concerned with
Yes, no one doubts the authority of the High Court to issue whatever.
I am a concern
outside
for the
rules
refund by-
jurisdiction, but we cannot split the cause of action.
Well, actually, I am concerned about refund as per the scheme. I am not challenging the forfeiture and for the all this.
We'll pass orders, yes.
Yes, okay.
Item number 2.
May I please, Your Lordship? My Lord, the notice has been written unserved to the registry of the Honorable Court with endorsement on the postal envelope. It is there in the record, Your Lordship. That
For 2 and 3.
2 and 3.
I'm appearing for respondent 1, Your Lordship.
They are respondent number 1, she has received, and they are staying in the same house, but of course they have not received. With an endorsement, Your Lordship, that he is out of station, address is out of station.
Station, one shifted.
Shifted. So that means respondent number 3 shifted, that means he has complied with the degree of action. And so far as this one, respondent number 2 is concerned, Your Lordship, he is having knowledge. His mother was also staying, he has received the notice, respondent number 1. But respondent number 1, she has received the notice.
Who are you to respondent number 2?
Respondent number is son of the respondent number 1.
Your Lordship, but we
And
have
in-
instruction only for the respondent.
One tenanted
No,
premises.
we see the same house.
Yes, Your Lordship, tenanted premises, one
You are
tenant.
Arif. Okay.
Asif,
I'm
Arif.
Wahida Begum.
You are Munshi. You are
since this is that one,
Zahida Begum.
Zahida Begum, Lordship. Respondent.
Zahida Begum, so your children are Tarifiq Ali and Arif Ali.
yes,
So Tarifiq Ali she's shifted.
shifted.
Okay,
So,
then
and then respondent number
only
2,
Arif Ali is there.
he
Where
has
did
not
he stay?
he's staying the same,
Same.
but they have not received.
I have not received and only instruction for respondent 1 to appear, Lordship.
Your Lordship, and one more thing, Your Lordship, that respondent number 2, on whose instance the execution proceeding has been stayed, he is appearing before the London Trial Court, and I have brought this order also, Your Lordship, who is having knowledge also. He has prayed that since I have filed the petition before this court, execution proceeding may be kept in abeyance.
See the order. It's from the CIS.
Yes, Your Lordship. 2 occasions he has appeared, and it is in his knowledge.
Who's T. Chanda?
Advocate.
Appearing for number 2.
Yes, Your Lordship. On whose instance the execution proceeding has been stayed. And since I have filed, he is taking advantage that unless this could decide, that proceeding also not going ahead. So he is avoiding the service. So let this matter be proceed for hearing, Your Lordship.
Yes. Notices to respondent 2 and 3 have returned unserved. As far as respondent number 3 is concerned, the noting says that addressee shifted. And with regard to number 2, it is noted therein that he is out of station stop. As per Ms. Pandit, Leonard Counsel for the petitioner submits that with regard to number 3, as he has shifted, that means that he has complied with judgment and decree, and such no further actions necessary against him.
Yes.
Stop. With regard to the respondent number 2, it is submitted that the said respondent is residing the same premises with the respondent number 1 and well aware of proceedings before this court. Stop. To substantiate this argument, Mr. Exponent has produced a copy of the order sheet
Order sheet.
of title execution case number 1H2024 and submits that it's not his name not recorded here anyway, and submits that the orders reflect that the number that respondent number 2 is aware of the proceedings. So, in his view, the instant case be for hearing after 2 weeks. Yes.
Item number 3.
My lord, this is a contempt matter. Lordship on the last occasion has passed an order in which we have to come up with an instruction or an affidavit. My lord, I'm praying that if this matter can be taken up at the end of the board, AG will be in a better position to apply.
What's the matter about?
Regularization of service, Lordship. It's working since 1998. This is the fourth round of litigation, Lordship.
Where's the affidavit?
Affidavit has not been filed, Lordship.
My lord, may this matter be taken up at the end of the board. AG is on legs before the third DB, my lord.
But your Lordship, I wish to submit that your Lordship, I filed on this case for striking out the name of the respondent number 4 in this case. So it is on board.
Because, my lord, in when we entered appearance, we had made a submission that the issue of regularization is under process. So 6 weeks time was granted. When the matter came recently, my lord, we don't know the exact status of the entire regularization because the cabinet
Change councils?
No, they have not.
Then this is Estapa?
Estapa is our colleague, Lordship. Is my colleague, Lordship.
Not Mr. Paul's Estapa?
No, no, no.
A different one, okay. Okay, take up another one.
Lordship. Obliged.
Item number 4.
Please lodge. Lordship, we have some more time, Lordship, to file affidavit.
What we have to make, Mr. Who's this contemptor? Frederick Roy Karakmar appear in person next date.
Lordship, my apologies, Lordship.
If contempt matters are taken so lightly,
Lordship, on the face of it, Lordship, there's no contempt, Lordship. There's no willful disobedience of this honorable court's order.
then
Lordship.
where's the affidavit?
Lordship, my apologies, Lordship. There's some difficulty. Lordship, can
You know,
grant
let
one
me enlighten you all with regard to contempt, the way the High Court's take it before. Once a contempt is filed, then notice issued, the contemptors appear on the next date when the matter is fixed.
Lordship.
And then if there's no contempt made out, then his personal presence is charged. But now, since so many contempts have flooded the court, that's why it's a more lenient attitude taken. But if it is not forthcoming, then we'll have to take recourse back to the old system. So once a contempt is filed, we issue notice, we ask for personal appearance. Another personal appearance dispensed with the court is to remain in court when the matter is taken up.
Lordship.
We'll have no choice because that's the only way to take out the affidavits, so whether orders of the court have been complied or not.
Lordship.
That's the only thing.
Lordship.
Because the systems have changed. I mean, it's changed due to, many maybe frivolous complaints. But then when we have to take recourse, we'll have to take recourse to that. If absolute file within time and further time sought all the time. In contempt matter.
Lordship. Lordship,
1 week for the time was prayed, yes.
Highly obliged.
You're making arguments saying there's no, then show it on affidavit.
Lordship,
I'll ask the officers themselves to say that no contempt be made out.
By end of this week, I'll have the affidavit on board, Lordship.
Item number 5.
Highly obliged.
It please your Lordship. Lordship, in this matter, we have already filed an affidavit. So the petitioner, your Lordship, in this case has already received his GPF upon retirement. So, Lordship, recently, a recent development has come, Lordship, that on the 12th of July 2024, the petitioner has also received his leave encashment. So what is remaining, your Lordship, is the gratuity and as well as the monthly pension. So for which, Lordship, the pension papers of the petitioner has been forwarded to the office of the Accountant General. Lordship, it's pending verification.
Yes.
Matter may be disposed of, my lord. A time frame may be given to them to dispose of.
Where's the affidavit? Where is stated that in the affidavit? Which paragraph?
Paragraph 7.
And when did he get his leave encashment?
The leave encashment, Lordship, it has been, it is on the 7th para.
No, leave encashment, he have received leave
received.
When did he receive it?
As per the affidavit which you have mentioned is on 23rd July 2024, my lord.
25th June?
23rd,
July, okay.
23rd July.
Okay, take down.
Now what remains, my lord, is gratuity and the pension.
Yes, gratuity pension, yes. The respondents have in the affidavit at para 7 stated that the expeditious pension papers have been processed and he has received his GPF on the 24th of January 2024. And further, the sanction for leave encashment was granted on 12 July 2024. And the set amount was credited on 23rd July 2024. It's also stated therein, it's also further stated in the affidavit that the pension papers have forwarded to the, now where is it forwarded to the Accountant General? To the Accountant General A&E Shillong for further action. Stop. Next paragraph. In view of this developments, Mr. S. Shongwan, letter counsel petitioner submits that the matter may be closed by fixing a time frame for payment of pension and gratuity, which is still outstanding. The same is also not, accordingly, as substantial compliance has also been arrived at, it's expected that the remaining terminal benefits of the petitioner, that is gratuity and pension, be processed expeditiously and be released within a period of 4 months from the date of this order. 4 months, fine?
Okay.
Matter transposed to this purpose.
Item number 6.
Obliged.
Please, your lordships.
Yes.
But in this case, I am appealing with the petitioner, my lord. On last occasion,
Where
your
is
lordship has
rejoinder?
granted us time. My lord, for my part, my lord, it could not be filed by now, my lord. We'll be filing
Why?
by day after tomorrow, my lord. Particularly. My lord, some issues are to sorted out at my end, my lord. Because of my default, my
Mr.
lord.
Dubey, praise for allowed further.
1 week, Your Lordship.
But just by day after tomorrow, my lord, we'll file. Your lordship can
2
take
weeks
it
time
up
to
for
file
hearing
rejoinder,
after.
yes. 1 week's time. Less thereafter also. Yes.
Your Lordship, interim
My lord, the
preamble.
interim.
Still enjoying interim order till now. Without filing rejoinder,
My
yes.
lord, the further interim order, I have not been.
We'll vacate it.
So,
Yes, yes, okay. Interim orders will continue the next day. Yes.
7.
Your Lordship.
Yes.
I'm deeply obliged, my lord.
Here we are filing it today, my lord.
I've received a copy of the affidavit, Your Lordship. Your Lordship can have the matter after 2 weeks, Your Lordship. If we'll file a rejoinder if necessary.
Let's keep it submits that the after we find the cause of the day. So Mr. Vasanthev, opinion for the petitioners, please a matter be listed after 3 weeks, enable him to file the rejoinder if necessary. Yes, after 3 weeks, yes.
All right.
8.
May it please your lordship. Lordship, in this matter, the respondent number 5 is yet to file the affidavit. Rejoinder.
We have received the affidavit, respondent number 5.
You filed it? Who's opinion number 5?
I'm for respondent. I filed it.
Yes, you filed rejoinder to state respondents affidavit.
My lord, there are altogether 11 cases of the similar nature, my lord. In 3 cases, affidavit has been filed by the state. So, my lord, we'll file together, my lord, after getting in one affidavit.
You filed for 5, you filed.
I filed it.
When? It's not recorded here.
I filed on sometime September
Oh, yes, on 11th.
11.
Yes, sir. Affidavit we have conference has been filed. Stop. Council petitioner prays for allowed 3 weeks time to file affidavits. To file an affidavit in the instant matter and the connected matters also.
My lord, similar item number 8 to 18, my lord.
Yes, same order.
Thank you.
This also.
Seventeen. 17.
Please,
Yes.
Your Lordship. Your Lordship, I may be allowed 2 weeks time to file rejoinder, Your Lordship. 2 weeks time.
Number 4 file.
Yes, Your Lordship.
Yeah, number 4, Mr. P.T. Sangma.
No.
Number 5, right?
I'm for respondent number 4, my lord. We have filed a affidavit.
All of
We have
affidavits.
filed. We have
Yes,
filed
sir.
our
Yes,
affidavit.
MS1 Harshi, the council petitioner prays for how much time?
2 weeks time.
To file rejoinder to affidavits filed by all the respondents.
Much obliged.
18. 18.
My lord, the state has filed the affidavit, my lord, and
number 4,
the managing committee is yet to file.
Your Lordship, I pray for some more time to file affidavit.
Why? Where is the school located?
This is in, my lord, West Garo Hills, my lord.
How much time?
2 weeks time, Your Lordship.
What's your name?
RM Shadab.
R.L. Shadab.
RM.
R.M. MS RM Shadab, contact number 4 page 4 is allowed for a 2 weeks time to file affidavit stuff.
All right.
Much obliged, Your Lordship.
19.
Hey, please, Lordship. Lordship, I pray for further 2 weeks' time, Lordship, to file my
Why?
rejoinder.
How many times you asked for rejoinder?
This is the third time.
Second time.
This is the
Third time.
last time, huh? Remember that. Yes, so further 2 weeks time. As a last opportunity granted for rejoinder. This is an afternoon.
20.
For affidavit, I'm paying for some more time.
Who's for the West Mr. Kumar? 2 weeks for the time is paid. Period is.
21.
Wait, please, Your Lordship. State has filed their affidavit. We've received a copy today. So we've just pointed it out to them that there are 2 annexes which are not very clear. We asked them for a copy. I may be given some time to file a rejoinder, my lord.
Where's the affidavit? File state. What 2 annexes?
My lord, page number 13 and 14.
Legible. Yeah,
This copy is also legible.
exactly.
What is this?
These are clarification letters, Lordship.
No, what is annexure 5? What is this? Receipt, what is this?
So this is a letter written to the state by the respondent number 5. A lot of it is not legible in the copy that we have received, my lord.
Showing the repeat fees.
My lord, we have served copies to the private respondent also. It's a clear copy, Lordship. I don't understand that. Then at the same time, Lordship, if they say it's not legible, then we'll give them a type copy. But it's very clear, even the court's copy, my lord.
No, see that. Is it very relevant?
It would be relevant, my lord. My date is not legible at all. I received it this morning.
It's 20.
What is the miscase?
This case is for stay, but lordships have passed the stay out on the main case itself.
Okay, this is matter after 1 week.
Lordship. But since I'll have to file a rejoinder, my lord, it's 2 weeks. I'll pray.
This is matter of 2 weeks for rejoinder.
Lord,
So this is a stay order, my lord, which is
I've already filed my affidavit, my lord, on the last date. We have served.
Take the next date then. Yes.
Lord, stay order may kindly continue, my lord.
Yes, interim order to continue.
Obliged.
Much obliged, Lordship.
22.
Please, Your Lordship, I'm entering a appearance for respondent number 5, Lordship.
Who's 5?
5 is HDFC Bank branch manager. As far as respondent number 4 is concerned, that position does not exist. It's only his branch manager. It's notice for 4 and 5.
1 second. Number 4?
4 is the chief manager. No such position is.
Chief manager.
There's no such chief manager. It's just branch manager.
Yes.
Your
We'll take
Lordship,
it off.
we'll take instructions, Your Lordship.
Chief manager. Mr. S. Marpant entered appearance today on behalf of respondent number 5 and submits that and further submits that there is no such office or respondent number 4. MS of Karmanang, then there's paragraph. Please will have to obtain instructions. Yes, what do you want today? Further?
I'll file my affidavit, detail affidavit.
When are you giving the money back to the petitioner?
That I'll clarify, Lordship. There's no wrong committed by the bank. I will place a detail.
Auto sweep.
Sorry, Lordship.
Is by auto sweep took the money?
No, there is a regulation of the RBI where there is a dispute. The first thing that the bank does, as per the RBI regulation, is that they do a shadow credit, which is not the actual credit, but it clearly mentioned the statement as under review. It's not an actual credit. That is as per the RBI regulation.
Here, it can happen to anybody.
Yes.
Right. Now you just, you've been scammed and you send the amount. Fine, you scammed, send the amount, whatever procedures, all right. But in this case, you've been scammed, you send the amount, debited from your account, you made a complaint, money was retrieved and reverted back to your account, again taken out. How's that possible?
Money was not retrieved. That is just a shadow credit.
Yes.
As per the RBI regulation, I have the regulation here.
Shadow credit means what?
It's not an actual credit. It shows in the statement
What's
as
the
under
bank
review.
liability in such cases?
But the bank, that is the regulation
Once
of.
alerted with regard to the wrongful payment, what is the action the bank takes immediately?
That's what we do, a review. The first internal
After how long? Now, when was
within
it,
10 days we have.
alerted to the bank what
Yes,
the
Your Lordship, I want, because Your Lordship, if it is reported within 3 days, like zero liability of the customer, but I have reported within, not within 24 hours, Your Lordship. And Your Lordship, I was questioned by the investigating officer that.
No, fine. No, it's just that. You just want to know what is the procedure the bank.
I will
adopt.
show it in
Because these
detail.
scams are happening every day, right?
Exactly.
So now the money is gone. You make a complaint. You find that it was gone wrongly. You make a complaint. Now, what is liability of the bank? The bank.
The first thing.
Liability, like you make a shadow. Suppose 1 lakh goes to my account. You make a shadow
Immediately-
credit account, and then you.
Exactly.
It reflects in my balance, and then
as under
after
review.
it goes out again.
Can you see the statement which is enclosed? It shows under review. It's not an actual credit.
In your
Call it
Lordship,
shadow.
it's
It's as per
under-
the RBI regulation. I have the regulation here. That is and it's also been done by the central, not by the bank here. The branch done by the central office there in Delhi. I will submit a detailed affidavit to explain all those things.
So what happened to her money in the meanwhile?
Because we found that the money which has been transferred was not nothing unauthorized had happened. So for that reason, it was closed, and an email was sent to the petitioner.
Not unauthorized means she
Had done it by herself by an OTP, UPI OTP.
Right, but that all payments happen by OTP.
Exactly.
Then
So after that has been reviewed, we found that there was no unauthorized transaction. So we have sent an email informing there's no unauthorized transaction.
no, what's happened is other things regarding the scams with this Amazon gift cards. That amount has been reverted.
Because the
back
money to
people
whom
who've
the
been scammed.
petitioner had sent it also, that particular account also is not with us. So there's other option is that she had to address it to two different forum. The first one is before us, and it was sent to the grievance cell also.
You
The
can't
internal
get caught
enforcement.
red tape.
There's another. we've
As
sent-
a very small balance in the bank, you want to subject them to further harassment.
Lordship, allow us to give a detailed explanation to the
Lordship,
whole
we have,
matter.
we have also stated in our complaint to the bank that it's a scam on para 4 of the complaint.
We will clarify it. Give us a time to submit an affidavit to clarify the whole thing. That nothing wrong has been done by the bank.
Otherwise, this matter comes out in public domain by court order, then your bank's credibility will.
We'll have at least your opportunity may be given to us. We'll explain there's nothing wrong.
Which have
We
to
will strictly
be
follow.
approved by the bank, whether even like they holds any policy with regard to small, depositors. If you can write off NPAs amounting to billions of dollars, then what is the other standard you adopt with regard to small deposits, money been taken away? They need support. They need money immediately.
Exactly.
Suppose
That is
someone
all
has to pay
subject to
school
review.
fees, or someone has
If
to
it is found
If it's
unauthorized-
scam, you don't have any bank. You don't have money in the bank. What's going to happen? People will die. You have to take your children out of school.
Once a complaint is made, we would always take it up. Give us time.
Why
to
don't
explain.
you remit the matter back and then later on that time you take your grievance cell, your ombudsman, your chief
So those
manager.
are the,
Then that time
those
you
are the
sit, have
forum that the
meeting.
petitioner should have approached.
May I please, Your Lordship? I beg to submit to Your Lordship one line only, Your Lordship. Because following my complaint to the bank, it was uploaded to their grievance cell, and I was investigated properly through their investigating officer. Your Lordship may kindly come to page number 37, Annexion 9, Your Lordship. Annexion 9, page number 38, relevant paragraph, where I was questioned, and I said this thing happened. Then she said, Priyanka Sharma, her name. She said I was besides I was investigated over phone on 14/8/24 and told that who had done it is a fraudster and the amount of rupees 99,000 has been traced out and money is on hold. Thereafter, I received the mail from the SDFC.
Money was on hold.
Hold.
Samarpan, you file after within 1
Yes,
week.
yes.
It is on
Give us
hold
3
and
weeks,
it is-
I'll explain the whole thing. There's
Otherwise,
nothing
you-
wrong committed.
You'll pay commercial interest on the amount.
I'll explain the whole thing.
It is my money, Your Lordship. How can they hold it, Your Lordship?
They have to actually insure the bank account also, my lord.
Yes.
There has to be some sort of insurance to those accounts of the public, my lord.
Insurance burden the poor depositor with insurance
No,
money.
by the bank itself, my lord.
They don't need insurance. They're the people who have all the money. Why should they have insurance? That is nothing.
23.
Lordship, 4 weeks, Lordship.
Not Your Lordship. I am Your
2
Lordship.
weeks.
I'm-
Yeah.
It has to go all the
No,
way.
Your Lordship,
Mr.
At least 3 weeks.
Police was allowed 2 weeks
3
to
weeks.
file affidavit. Yes.
Your Lordship, one week.
Otherwise, we're not putting in paper, but then we expect that money goes back to her account before the next date. We're not saying anything. Just
Our affidavit will
that
explain.
is you just apprise your
Exactly.
people. Yes.
Yes, yes.
Not to be so rule bound. Yes.
Lord, pursuant to the last order, my lord, we have served Dusty, my lord, and we have filed the affidavit this morning, my lord.
Who's appearing?
Lord, kindly have my affidavit. This is the Meghalaya Pollution Control Board.
Now, who's appearing?
Lord, nobody has appeared. We have served notice.
They file affidavit also.
I have filed
Oh,
affidavit.
yeah,
Lord.
okay. I thought they have filed affidavit.
No, my lord, I have filed my affidavit.
Affidavit indicating service upon the respondent number 1.
One, my lord.
Has been filed today for the court. The same is taken note of. Stop. However, no appearance is made on their behalf. This is a matter next week for appearance of respondent 1 is.
Lord, in the meantime, my lord, I have filed a miscase, my lord, because my unit has been, my lord, sealed. It's a trading unit, my lord. I trade in rubber. And my
We'll have
lord,
it next week. Yes, it's on.
the order, impugned order pass is absolutely illegal, my lord, because
We'll have
section
it next
25.
week. Let them, if they don't appear, we will pass orders.
My lord,
Is it on?
deeply-
Tuesday. Tuesday this is the, sorry,
Tuesday is first, my lord. Deeply.
Hearing, supplementary list, item 53.
yes, Mr.
My lord. My lord, this is a challenging the transfer order, madam. The petitioner here challenges the transfer order dated, my lord, 22nd December 2020, 27th December 2022, my lord.
Yes.
That is at Annex 5, page 37, my lord.
Yes.
My lord, prior to this transfer order, my lord, which has been passed, my lord, the respondent authority, they themselves has cancelled the transfer order.
The same transfer order?
Of this petitioner. My lord, can come to page 33, my lord.
How do we say prior to this order it cancel the transfer order?
My lord. Prior,
can you cancel something that's not been issued?
Which was issued, my lord. Transfer order was issued prior to this transfer order also.
The 21st April 21.
Yes, my lord. That was cancelled, mal.
Annexure 4.
Mal.
Yes. Yes.
My lord. Thereafter, my lord, we file a representation that that impugned order, the transfer order may be cancelled on the two grounds. On
No,
the,
see, cancellation of posting order so and so, your earlier order to for AR while the actual posting is either cancelled due to issues involved in disciplinary case.
Mal.
So this order is dated 21st April 21. 21st 4/21, right?
Mal.
It was cancelled.
Cancelled.
Yes, posting order dated.
Posting order, my lord, 29th April 2020.
How can 29 April 20? Okay, after 1 year. So 29 April 2020, posting order was issued. You didn't move.
No.
Why?
That was a disciplinary proceeding was going on.
So it went on then 29 2020. So 21st April 2021, after
They have
nearly 1 year, then he cancelled his 29-1.
Mal.
Okay, then.
Thereafter, my lord, court of inquiry was proceeding, my lord. The disciplinary proceeding was going on, my lord. Suddenly, 2022, my lord, they again, without giving me the finding of what was the finding or whatever the thing, they have issued the transfer order. I was not known what's going on. It was the court of inquiry was basing on that I have taken out documents from my own service record. From my service record. For that wherein I was blameworthy. The petitioner was blameworthy. So nothing was given. Suddenly the transfer order was issued. I said that on two grounds, you recall this transfer order. On the ground, till the disciplinary proceeding is concluded, I should be retained here. And secondly, one similar case, which is I have filed a complaint case, I have filed before the court of the CGM, that till that disposal, I being the complainant, I have to appear, till that disposal, I may be considered now. Even after recommendation by the commanding officer, my lord.
Yes.
The commanding officer, my lord, that I will take to page 40 of the affidavit filed by the respondent authorities.
You're working as what?
I'm working as a nursing assistant, man. I'm rendering the services without any hindrances, man. Without any hindrances, without disturbance.
Yes.
My lord.
40.
My lord. It starts from, my lord, page 39, prior to that. Recommendation by the Chief Medical Officer. Hospital. Number such and such was posted to headquarter, was posted from headquarter IGR to Assam Rifle Hospital, such and such, with effect from 9th April 2017. Number such and such, Bipin Upadhyay filed a CR case number 27 of 20 against Neeraj Kumar of 23 Assam Rifle, first class judicial magistrate Shillong. Number such and such, Bipin Upadhyay posted on 21st to 21st Assam Rifle by number dated 27 December 2022. Individual submitted an application for extension of tenure to Shillong to attend the hearing. The case of the two individual level of such and such, whom case were filed has already been returned to parent unit, that is 23rd Assam Rifle. The hearing of the, moreover, duration of the ongoing court case is also not known. Individual can also attend the court from such and such unit. Therefore, in view of extension of such and such
Is not
is
recommended.
not recommended.
So
My lord.
your posting was recommended, yes.
My lord, next page, my lord.
Then,
My lord.
but CM Commandant?
My lord.
No.
That was CMA, my lord.
Assam Rifles Administrative Support Unit.
It,
the other one by the
by the-
Commandant, CMO.
CMO, the Chief Medical Officer, my lord, under whom I was working. It is by the Commandant where I am serving.
May be sent on posting and be attached to. What does it mean, this one?
My lord, it is recommended that number such and such be sent on posting to such and such and be attached to a unit, oblique formation nearest to the place where the court is situated in terms of the regulation. In spite of this recommendation, my lord, I am praying that I may be that the court of inquiry may be complete. I may be, because so that I may be able to attend the court and finish the case, my lord.
The case CJ will take forever. The minister will retire, will be.
No, my lord. That is in the final stage, my lord. It will be on the next date. Charge will be framed and thereafter, my lord. Because that
charge will be framed. Charges have been framed till now. I like that. Yes, that's a very optimistic kind of submission. Yes. Yes.
Yes, my lord.
Yes.
Here the petitioner is as of, my lord, has he not been, my lord, and it is not that, my lord, the other unit where I have been posted, the said unit is suffering, my lord. The affidavit is totally silent, my lord.
Huh?
Where
suffering?
I have if in my absence, my lord, where I have been posted, it's the unit is facing any harm due to my absence. I have been performing my duties here, my lord.
There's no question of feeling hard. When you go there, you'll add to them. You'll become better. There's no question of they're having hardship. No, you'll improve the quality of the medical care once you go there. Yes. Where's 21 Assam Rifle located?
It is in Manipur, man.
More than you would require there, yes. Yes. What else?
In nutshell, my lord, this is my case.
Here, Dr. Muzika.
My lord, as indicated, they have taken two grounds, my lord. One is that some court of inquiry
What happened with PUI?
My lord, page 29 of my affidavit, my lord, Lord, kindly take, sir.
Yes.
This is the order by which the COI proceedings have been concluded, my lord. And the order says, my lord.
Yes.
Certain directives were given, my lord, because what he did, he stole some pages from his own service book, my lord, which were adverse to him, and that was caught. So the directions were necessary entry in seat roll of individual be corrected, filled up with the missing data.
Yes.
Advisory be issued to record branch to streamline the measures to avoid such lapses incidents in the future. Automation of records be done. Disciplinary action cannot be initiated based on the findings of the court. The case to be disposed of with the order. So by this order, the matter was closed against him, my lord. And as far as criminal case, my lord, the criminal case, he is the complainant, my lord, in a CR case, my lord. Page 39, Mr. Jha has pointed out, my lord. I'll just point out once again, my lord.
39, yes.
Now this recommendation, my lord, in para 2, Mr. So-and-so, Vipin Kumar Upadhyay, who is a petitioner, my lord, has filed case number CR number 27 against Neeraj Kumar of 23 Assam Rifle in the Court of First Class Judicial Magistrate Shillong. Number so-and with Vipin Kumar Upadhyay, extend posted to Assam Rifle, wide number so-and-so, individual has submitted an application for extension of his tenure in Shillong to attend the hearings. The case is between two individuals at their personal level, wherein number so-and-so Neeraj Kumar, against whom the case was filed, has already been transferred to his parent unit, that is 23 Assam Rifles, attending the court hearing from his unit. However, the duration of the ongoing court case is also not known. Individual can also attend the court from his unit. Therefore, in view of the work, extension of posting is not recommended. Now, the accused person has been transferred out, my lord. He is the person who is more required in the trial, my lord. He is only a complainant.
No, my lord. Accused gets the under 205 exemption, my lord. Exemptions, my lord. Where the presence of the complainant, my lord, is necessity.
You have to pursue his case, otherwise
Yes, my lord.
your case will come
In
stale.
absence, may be dismissed. So he, in the second.
Now there's this thing here, no?
My lord?
Called virtual court. Even from the phone you can do also.
My lord, it's remote areas, my lord.
The phone, you can do on the phone also.
And the second aspect, my lord, he was transferred in Shillong to Shillong, my lord, 2017, my lord. Against the usual norm of 3 years, he has completed 7.5 years till now, my lord. So, my lord, he must.
2020, you've been Shillong.
2017, my lord. Since 2017.
Since 2017, you've been Shillong.
He is in Shillong, my lord. So he was due to be posted out in 2020 itself, my lord.
In between, they have 19, my lord. They have issued the, which was cancelled by themselves, my lord. In between, there was no posting order, my lord.
Okay.
That was the respondents, my lord. That was cancelled, my lord. Prior to this transfer order, they themselves has cancelled it.
Anything else?
That's our case, my lord.
No.
But these are not the grounds for.
No, the only concern of the court was that the CUI proceedings. It's been closed over there.
My lord, Court of Inquiry proceeding, where is the copy of the proceeding? Why the.
There's page 29.
My lord, a copy of the proceeding where.
Nothing being done against you. So no dispute proceedings are going to turn up against you. So what you want to do? On your own, you can represent against the findings of that what's been given to you.
My lord,
They said if taken out the records, then fine. They've said inserted it back, but no, nothing. There's not even caution against you also. Nothing.
No adverse order.
My lord, I have filed a representation, my lord, under 187, my lord. Give me the
can
copy.
find many ways you can settle it, but it's a matter of transfer. And I don't take too long. Okay. We pass orders. I want to pass over the court any.
Some brief facts if you wrote lots of.
Take a brief fact, yes. Next.
DP.
(24)
At the time of hearing, Your Lordship, the petitioners wanted to take instructions on our documents.
In fact, if Your Lordship be kind enough to come to the order dated 9/7/24, Your Lordship.
Nine 7/24.
9/7/24, Your Lordship.
Yes.
By this order, Your Lordship, the state respondent was directed document instructions as to who is the signatory of the annexure to, Your Lordship. But
You've
they are
already
still,
done that, Your Lordship.
they are yet to come with their instruction, Your Lordship.
No, but
In
last
fact,
time
he was asked to get instructions.
if you look at order date 9/9.
Yes, this is the order, Your Lordship, 9/7.
No, see the last order 9/9/2024.
Nine.
9/9 of
September.
you were supposed to seek instructions on the papers we had submitted.
Yes, Your Lordship. They have, Your Lordship, what happened in the last round of litigation, on the last hearing, Your Lordship, I mean, my first prayer to set aside the impeach order, Your Lordship was not inclined to pass any order with regard to that, Your Lordship. So I came up with the alternative prayer, Your Lordship, and that is to direct the Chief Secretary to dispose of my appeal, Your Lordship. So with regard,
The order even
yes, Your Lord, no, with regard to that, Your Lordship, they have bring in record some documents, Your Lordship. And this document, they have made a submission that the Chief Secretary, that before the Chief Secretary, that we have already filed an appeal, Your Lordship.
Yes.
We have already filed a written argument. That is the submission given.
Written order.
Yes.
The order's been passed, yes.
No order has been passed, Your Lordship.
What is this then?
No order has been passed on the ground that this matter is still pending, Your Lordship. That is the last submission given by them, Your Lordship.
They will close it.
With a direction, Your Lordship, that my appeal may be.
No, that has already been disposed of, Your
The
Lordship.
action, this up to you, 30th November 22.
Yes, Your Lordship. This is yet to be decided, Your Lordship.
It has been decided.
Subject complaint. So this is you sent it, right? 22.
Yes, Your Lordship.
Now this is we come to discuss the matter so. Written statement.
This written statement was not filed before the Chief Secretary, Your Lordship. If Your Lordship look at the date of written statement, this was filed on 27 August 2000.
This the report has been filed by whom?
If Your
Our
Lordship,
annexure 11 to our affidavit is
if
clear.
Your
Your
Lordship look at the written statement, Your Lordship,
This is in response to the letter
second,
number
one second.
nil dated 30th November 2022. But because this was not signed, Your Lordship had asked us to get some proof that it was issued by the Chief Secretary's office. Then we have submitted that letter where a forwarding letter is there. Yes. It is, in Extra 11 clearly says, complaint filed by so-and-so, so report on the affairs of the Sintung Integrated Village Cooperative Society Limited.
What is one actually 11 years?
In response to the letter
same one
dated
is here again.
30th November.
This is
So we
fact,
have
right?
produced another set of documents to show that this
The same
was,
one.
that this
But here
representation filed by them has been.
section 16 in the clarification. Signed by whom? You said this is a.
The forwarding letter, Your Lordship.
they have not clarified, Lordship, who is the signature of this document, Your Lordship, of this
Yes,
order.
Your
There are
Lordship.
societies.
26th May 2023, Your Lordship, is by the Registrar of Cooperative Societies, by which this report has been enclosed, forwarded, Your Lordship.
Here's the report. Yes. What more do you want, Mr. Majao?
I think
That's why it's the same thing. We had the same. You go back to YouTube and see same. The operation happened. That's why you wanted to take instructions.
Because on last occasion, Your Lordship, they have made a statement, Your Lordship, that I have filed my written statement based on the appeal. And they have made a submission that.
No, I think my friend is confused.
Yes, Lordship. There is a submission made by them, Lordship, and they cannot dispose of the appeal because of the pending litigation.
We have never made such a statement, Your Lordship. We have
It is on
said
the
that
record, on the record.
representation made
What you have
before
to
the
say-
Chief
what you have
Secretary
to
has been
say-
disposed.
See, report on the complaint filed with Atyata Khar and C. Welking Singh Suting, which is you, on the affairs Sintung Integrated Village so-and-so, in response letter dated 30th November 22 by the ex-chairman. This is the one given by you, right?
Yes, Your
By
Lordship.
30th September.
Yes,
So this has been addressed. Do you have any grievances with the way it's been addressed?
Because what I'm saying, Your Lordship, because I have not been heard, Your Lordship, before passing this order.
Doesn't matter.
This order was never communicated to me.
If
They have never,
They never communicated to me, Lordship. No, I
they
was
have
given an
never
opportunity to be
complied
heard
by the
before passing
rules
this
and
order, Your Lordship.
regulations of the society, Your Lordship. They did not conduct the elections on
That I
time.
concede from the
They did
beginning, I
not have the meetings
I
regularly.
conceded to that from the beginning, Lordship.
Yes.
And now,
You conceded from the beginning.
Yes, Your Lordship.
That you didn't have meetings.
No, Your Lordship, I concede that, Your Lordship. I came here as a member of the society, not as chairman or secretary, Your Lordship.
Your Lordship,
but
I
the
am,
Secretary has,
Your Lordship, I am representing the chairman, and the particular society has not been in operation since 2018. And ever since, reminders have already been given to them, vote have been taken from the members
Yes,
of the
take down.
society.
Yes, the writ petitioners by way of instant petition have assailed the where's synopsis? Have assailed a special meeting dated 10/1/2022 which they allege was held in their absence, and that the signatories of the special general meeting, only 5 members thereof were actual members. So, Before that, before we come to that, sure. Yeah, yes, the writ petitioners. The writ petitioners was stated to be your ex-chairman, no?
Yes.
The writ petitioner, who number will be more specific. Number one. Number one. Number one. We have not said anyway, yes.
Yes.
Number one is stated to be the ex-chairman of the Santung Integrated Village Cooperative Society Limited, and the other petitioners are stated to be members of the said cooperative society. Next. No. The grievance of the writ petitioners is with the special general meeting dated 10. But remember, the further grievance is that by another impugned order dated 13/1/2022, the resolution taken in the special general meeting approving the new office bearers of the society was approved. It has also been contended that though a complaint was filed as far back as on 30/11/2022 addressed to the Chief Secretary, no response has been forthcoming. Mr. Majao, Leonard Concept Petitioner, has admitted in the submissions, has tried to impress upon the court that the provisions of the Meghalaya, that is the Meghalaya
Cooperative Society.
Societies Act, have been violated in the manner in which the new members were incorporated. And also the lack of credibility of special general meeting. However, today, as on last date of hearing, submits that at least before the matters taken forward, the complaint filed by the petition others dated 30th November 2022 be addressed. So, next paragraph. Ms. Tiangi, EAG, in reply, has referred to the affidavit filed by the state respondents, wherein the complaint filed by the petitioner has since been disposed of. On 26 5/2023. So,
Right, Annexure 11, Your Lordship. We have
Yes.
attached that report there.
and the report has been annexed Annexure 11 to the said affidavit. Next paragraph. At this juncture, Mr. Armajao has raised other objections on the ground that when the said report was issued disposing of the complaint dated 30th November 2022, the petitioners were not given opportunity of being heard. Next paragraph. This court, on hearing the counsel of the parties on examination of the materials on record, notes that with the disposal of the complaint stroke representation is 30th November 2022, the same has given rise to a new cause of action to which the petitioner can avail of appropriate remedy. And further, should we record that you admit that the meetings were never held? No.
No.
Yes. Problem. And yes. That has given rise to an equal action. Can assail by resorting to appropriate, can by avail of remedy to assail the same stuff. According to this stage, as the matters taken at as and according to the stage, is deemed fit that the petition be closed, leaving the petitioner liberty to avail of any other remedy. That's maybe advice is. Matter sounds close in this program. You challenge it.
In fact, that order, that report was never communicated. That's a problem.
You see, that is all grounds for 226.
Is that
Who's appeared Dilip Basfor matter? We have hearing matters at 2:15. We'll just please order matter first. Dilip
25 is-
Basfor.
Item 3.
Obliged, Your Lordship.
25.
Dilip Basfor, you're there.
Lordship, item 3, this is for orders.
For item number 30.
No, we're not taking mention now. We just the order matter.
Yes,
You do are there any urgent hearings? Or you having the syndrome? Yes, Mr. Gautam.
Well, 31. There is some urgency in the matter.
We'll have it at 2:15.
My lord, in item number 31, that where my friend is the petitioner, there's some mistake in my affidavit, my lord. Which was not this thing came to my notice, my lord. So, my lord, if my lord may please allow me to correct that in the name, my lord, in the name of the hetman, my lord.
What is that?
Well, just the name, I believe, my lord. Something's wrong with the name.
And also,
Subject matter, otherwise.
And also, my lord, on the last occasions, my lord has taken cognizance of one letter written by the Rangwach Nong, my lord, to the deputy commissioner, my lord. So that I need to clarify.
Oh, that's a very serious matter.
Yes, my lord. Yes.
He has
My lord,
yes,
yes,
written to the authority.
Yes. So, my lord, we regret of writing such. The language could have been toned down, but under what circumstances it was written, my lord, I want you to bring on record, my lord, because this land is claimed by MIDC also, my lord. MIDC also has been asking us to demarcate the land, my lord, because somebody has mortgaged this land to MIDC and took the money and subsequently was not able to pay and in the
Tuesday, day after tomorrow.
my lord.
Day after tomorrow then.
My lord. In the meantime, my lord, allow me to bring supplementary affidavit, my lord. My lord, obliged.
Much obliged.
Obliged, watch.
Yes, number 3.
25 is there in the list. Ravi Guru is the other side, my lord.
Which one?
25.
Where's the petitioner? S. Shyamjit Thapa, A. Sangma Komalai, and Latu Arguru.
No, listen. In fact, the matter was heard by Lordship. Mr. Guru took time to do some research and place the judgments.
Maybe he'll come at 2:15. Yeah, other matters take up to 15. Number 3 also no one's there.
28 is also better. Jaiz.
They made a submission in the morning.
28 you want to do?
28
what?
Assam Rifle Service matter.
Who's for the, where's Mr. Jha?
My lord, I'm here.
You ready?
My lord, on the last occasion, my lord, the matter was heard and senior counsel was asked to get the instruction, my lord. By which order the punishment of 14 days was awarded, my lord.
I have the order, my lord.
We'll have it then at 2:15. Yes.
My lord, the order copy may be given to us so that I can
give it to him.
Adequately reply.
Today or you want the time?
Item number 3.
Yes.
My lord, we have received a forwarding letter, my lord, from the department that.
Appointment letter?
My lord, yes, informing that the petitioner's case has been placed before the cabinet, my lord, for consideration. That is the latest development. The letter is 23rd of September, my lord, yesterday. So that is the instruction which we have. And it appears that the cabinet will be coming up, my lord, in which is for approval, my lord, for approval. Lord,
We'll close it, Mr.
Lordship, this
Mr. Deb.
proposal placed before the cabinet was the same position in 2021.
Really?
Lordship, may kindly see the order.
Let's see the letter.
My lord. My lord, the ending part of the letter says for approval, not for consideration.
Yes.
So there can be some hope here, my lord.
Yes.
Because in the previous round, there was a word which says consideration, for further consideration before the cabinet. This is approval.
Anyway, communication is produced dated 23rd September 2024, whereby the regularization of the petitioner has been taken up and will be placed in the cabinet shortly for approval. This is the matter after 4 weeks, yes. So waiting for the orders. Operational communication is taken on board and made part of the recordings.
Lordship, apart from this, there was a miscase filed by the fourth respondent, Lordship.
Yes. Striking of.
Yes.
Case number?
Case number 6, Lordship.
6. This is an application striking off the respondent of 4 other parties. And the said respondent relevant service seemed not objected to by counsel for the petitioner. The respondent of 4 is struck off from the rear parties. Miscase upon disposal.
Yes, my lord. All because what is happening, my lord, that there are other proposals which have been left out. So we are collecting all of them together and we are placing the book.
Yes. Next matter.
25.
Yes, Mr. Guru. Going to appear for the petitioner just after 3 weeks. Any urgency?
This was seeking promotion, my lord, and he has been denied on medical ground.
28.
Yes.
My lord.
Yes.
My lord,
instructions.
I have received the instruction. I have to examine that. I will require some time. I have to get the instruction. They have supplied me the copy.
Let us see the copy also.
My lord, the other, in this matter also I have raised the issue of territorial jurisdiction, my lord. Everything happened in Punjab, my lord.
Oh, is that fellow went on that NDRF?
My lord.
Who gave order for 14 days imprisonment?
By NDRF, my lord.
By NDRF? Commandant 13 NDRF. So finished.
I will come back. My lord, that NDRF, they are the officers of the Assam Rifle. I will.
Doesn't matter. Once you're on deputation, if you're in a different kind of what do you call it? You're under NDRF. That means whatever actions happen there is under the jurisdiction NDRF and under the territorial jurisdiction of which the NDRF operate at that time. That means with us, a lot of officers go on deputation also.
My lord, that I will
see at battalion headquarters like Ludhiana. This is in see. Deputy commandants are here. Pursuant to the order dated 9/9/2024, Dr. N. Mozika, Leonard DSGI, has submitted an offence report which indicates that the order for 14 days rigorous imprisonment had been issued by the Commandant 1313 NDRF, bracket Assam Rifles. Mr. Arjha, please allowed to obtain instructions. Just after 2 weeks, yes.
32.
Yes.
Appearing on behalf of the petitioner.
Yes.
In this matter, Lordship, we have challenged the interim order dated 22/12/2022. Issued by the 22/12/2022.
Yes.
By such order, Lordship, there was an arbitrary removal of the petitioner as cow in violation of the principles of equity and natural justice.
In person order did also pass and by its also, it is to appoint Sri Azizur Rahman. You agree with this order appointing Azizur Rahman as Gaunpura? But the period is over. This is agree with this 22nd September 2022.
He's still in holding the.
Where's the subsequent extension order then?
That they have not placed, but there's a statement I have seen from the petition. And
We
he
have
appears
challenged
to
this
be
order.
holding the post today.
No, Chinese order is dead. There has to be a subsequent order.
The order is an arbitrary one.
Orders on a anticipated order, yes.
The order is an arbitrary one, Lordship. They're claiming that they have.
No, forget arbitrary one, but where's the subsequent order of extension?
Lordship will see page 22.
Of the affidavit?
No, of their writ petition. They have mentioned it, but it's not enclosed.
Where's the order?
Page 22. Paragraph 22 at page 22.
Lordship, we have tried, but we were unable to obtain the copy of the extension orders.
Where's the records?
Records have not yet been called for, Lordship.
He produces orders of extension. Then we'll produce it next date. Otherwise, how can we take cognizance? Yes, when the matter is taken up for hearing, it is noted that the continuance in office of the writ petition of the respondent number. Respondent number, this Azizur Rahman, respondent number?
Respondent number 4.
Number 4.
Respondent number 4.
The orders of, sorry, when the matter is hearing, the orders of continuance and service of the respondent number 4 are not on record. Stop. Comma, though it is undisputed that the set respondent number 4 still continuing in the office of Gaunpura. Stop. Mr. S. Dept will produce the orders on the next date, just after 2 weeks. How can you set aside something that's not on record or interfere? Yes.
Obliged.
Try to obtain such orders, Lordship. Much obliged.
33.
My lord, this is the matter relating to transfer. The connected matter is also there. Yeah. My lord, the issue, according to me, my lord, whether earlier also argument was there, especially from the HA side. The judgment delivered by the division bench in the convergent case is squarely applicable to these cases. Therefore, transfer application filed by all of us cannot be entertained or dismissed. And that is the argument. My lord, my argument would be, my lord, the judgment delivered in the convergent case is directly in contrary to the judgment delivered by Supreme Court in the Sulang Pao case. And in view of that, my lord, the Supreme Court judgment will govern the field. And indeed, in that view of the matter, convergent judgment cannot be met, binding to my lord. And in view of that, Lordship may consider this application for transfer. Now, we have seen, my lord, there are 4 types of notifications. We have combined types of notifications issued by the governor. I've compiled it. All these materials are available, but sequentially I prepared. My Lord, if Your Lordship permits me, I can see it. Please. My Lord, in these notifications, the first set of notification is Governor invoking his power under Para 5.1 and conferring power to the officer of District Council to try cases. My Lord. Second notification is, my Lord, Governor is invoking his power and appointing judicial officer under Rule 37, read with Rule 60. And the third notification is, my Lord, Governor issuing a notification invoking under 32, read with 36 and Para 5.1 with regard to Garo Hills and Jendi Hills, where there is no conferment by the Governor to the District Council. And last one is conferment, my Lord, to the Session Judge. Lordship, can you see the first page number 1, 2, and 3? This is the conferment to the District Council officer. But I will not take it. Lordship, can you see page number 3? Yes. Is the conferment. This is placed before the Honorable Apex Court. On the basis of this notification, judgment was delivered by the Supreme Court in
Page number 3.
Supreme Court case. Page number 3 is
7 February 2017.
7 February 2027.
Yes.
Yes. My Lord. Now, in view of this, Supreme Court held that in view of this conferment, District Council has the exclusive jurisdiction to try cases involving more than 5 years. And now, yes, page number 3. Now, so this is page number 1 to 3 is the first set of notification. Governor purely exercising his power under 5.1. And second set of notification, page start from page number 4. 4 to 9. Governor is exercising his power under Rule 37, read with 6 to 60. And appointing a judicial officer to act as a ADC under 37 to try cases. Here, admittedly, my Lord, Governor did not invoke 5.1, Para 5.1 of 62. He did not. And according to me, this is exactly a proper exercise of power under 37 rules and 60 rules. 60. Now, the third set of notification is, my Lord, start from page number 10 and 11. Yes. Page number 10 and 11. 10 and 11. Now, he has quoted, my Lord, 3 laws. If Lordship allow me to read this. Yes, the confusion started from him. Page number 10. In exercise of powers conferred under Rule 1A of the Rules for Administrative Justice and Police in the Khasi and Jendi Hills 37, and further under subsection 1, section 2 of the Meghalaya Autonomous District Administrative Justice Act, such and such, is adapted and amended by Meghalaya. Read with paragraph 5 of the 6th schedule of the Constitution, Governor of Meghalaya, with the approval of the Honorable High Court of Meghalaya, is pleased to appoint Sri Sansach, District and Session Judge Jawai, as the Additional Deputy Commissioner was Jendi Hills District for the trial of all offences punishable with death, imprisonment for life, or imprisonment for a term of not less than 5 years under the Indian Penal Code or under any other law for the time being applicable to the district, and also to hear all civil and criminal revision, appeals, etc. from the decision of the Assistant Deputy Commissioner within the said district. And the Governor is further pleased to direct that such district session judge as an additional Deputy Commissioner shall, for the purpose of our said, exercise all the judicial powers of the Deputy Commissioner within the said district, excluding Amlarem subdivision with immediate effect. However, all appeal from the Amlarem civil subdivision will lie with the Formation Court of Additional Deputy Commissioner. This supersedes all. Now here, my Lord, interestingly, my Lord, if we see paragraph 5.1, there is no concept of hearing civil revision, criminal revision or appeal. Now, this revision appeals and revision appeals, both civil and criminal cases, is arising from Rule 37 and Rule 60. Now, therefore, my lord, admittedly, this is for the gender hills. And the next is page 11 is for Garo Hills. So, admittedly, these two district councils, governor did not invoke section para 5.1, invoking power to conferring power to the district council officer. Therefore, my lord, according to me, my lord, this invoking insertion of 5.1 is a misnomer or by unintentionally voted. Because, my lord, the power to try cases, beyond 5 years, irrespective of all the parties, is retained under Rule 37 and read with 60. It is with the ATC. And now, since ATC, you have to separation of the executive from judiciary or judiciary from executive, all judicial officers are required to be appointed and to act as a ATC. And in that view of the matter, judicial officer can exercise the power of ATC under 37-60, and they can hear the revision or appeals. But whereas in the context of 5.1, whoever is confirmed by governor, that person is the first court, the court of first instance.
Okay, that's their argument now.
My lord.
That 5.1, that means Khasi Hills.
Yes, and now the other one, my lord, but page number 12 to onwards to the end, page number 17. This is the last fourth type of a notification. Well, para to your question, can you see? My lord.
Yes.
In exercise of powers conferred the such and such, Rule 37 and further such and such, 1960 as adapted and amended, read with paragraph 5 of the 6th schedule of the Constitution, Governor of Meghalaya, with the approval of the High Court of Meghalaya, is pleased to appoint Sri Sansad, District Session Judge Ripoy as the Additional Deputy Commissioner, Ripoy for the trial of all offences punishable with death, imprisonment for life, imprisonment for a term of no less than 5 years under the Indian Penal Code or under any other law for the time being applicable to the district, and also to hear all civil and criminal revision, appeal, etc., from the decision of the Assistant Deputy Commissioner within the said district, and the Governor is further pleased to direct that such District Session Judge as Additional Deputy Commissioner for the purpose of proceed exercise all the judicial powers of the Deputy Commissioner. This supersedes the earlier man. Now, my humble submission, my lord, when we look to the Lordship is very much aware that judicial structure before the arrival of the Constitution have been there. All the, my lord, judicial powers are under the 37 rules is exercised by the ATC, Lordship. Now, when Constitution is arrived, now 6th schedule brought a different framework, a special arrangement for the tribal area. It immediately, my lord, cases the amounting to, my lord, less than 5 years, straight away taken away under para 4, Lordship very much away, provided both the parties are coming from the same district council. Now, this is one of the special arrangements. Second special arrangement is, my lord, my humble submission is that para 5.1.
Yes.
Para 5.1 is still retained with the ATC, my lord, under 37 rules. This final arrival of the Constitution of India. Until unless Governor invoked that para 5.1, the power to try these serious offences is still retained with the ATC. Now, therefore, if Governor do not invoke para 5.1 in the context of the East Khasi district, this power is remained with the ATC, and since the separation took place, Governor can invoke this 37 and read with 60 and appoint the judicial officer to exercise ATC as ATC to try cases where both the party, my lord, or irrespective of all the parties, maybe tribal or non-tribal. But the moment he invoked, my lord, the power to try cases given to the judicial officer district council, when both the parties are coming from the same district council area, Governor cannot, my lord, Governor cannot create another parallel jurisdiction. Now, if, my lord, the argument of the state is that parallel jurisdiction are still going on till today. Now, forget about the Jinde Hills and the Garo Hills, since there is no conferment. But conferment is with regard to Khasi District Autonomous Council. Now, parallel jurisdiction is going on. Now, the state is the public prosecutor. It depends on the sweet will of the public prosecutor. If I want to prosecute before the session court, Nongpo, or Shillong, I can prosecute. If I want to prosecute before the district council court, also, I can prosecute. This parallel jurisdiction is going on because of the conferment of this nature. And this similar conferment, my lord, page 13 also is continuing. Page 15, in the convergent judgment, this was quoted, and the division bench emphasized that this supersedes all the earlier notifications. The division bench, page 13, page 13. At the end, my lord, this supersedes all earlier notifications issued under opposite provision within report district. Now, this was read by the division bench in convergent judgment as if that this has supersedes the notification given to the district council. That was, with the great respect, my lord, that was a mystery. Now, I will not play, now, Lordship kindly, page 14. Page 14, my lord. This is the notification whereby the state argued in convergent case. State placed this notification that in view of this conferment, appointment, session judge in report district has the power to try. And right or wrongly, my lord, division bench has rendered judgment that yes, in view of this notification, it can be tried. And this supersedes earlier notification issued to this effect under the opposite provision report district. So this was read as a superseding the district council conferment. It was never. But it was superseding the notification of 2015. Now, this is the notification. Well, that case is over. Now, page number 15, notification with regard to East Khasi Hills is placed on record by the government now. Page number 15. This was never placed before the division bench when we argued the case. The argument was only confined to report district.
15 is not placed, you mean?
Yeah, not placed before the division bench in convergent case. So convergent case was only confined with the report district.
Yes.
And now the state has placed this notification, page number 15, saying that the same notification issued with regard to report district is upheld by the division bench, and therefore similar notification is there for East Khasi Hills. So the transfer application filed by all of us from East Khasi Hills is not there anymore. Now, assuming, my lord, this is correct, now I would maybe permit to mention one of the transfer application here. Transfer application number 3 of 2024.
Yes.
This is from the West Khasi Hills. And with regard to West Khasi Hills District and Session Judge, no conferment, no appointment as such is there. So if the state come up with the argument that in view of this conferment, now District and Session Judge in Shillong can try cases coming from both the parties are tribal. They are resisting. Now, in that case, what about the transfer application coming from the West Khasi Hills? The West Khasi Hills become now 3 districts are there. 2 session judges are appointed. And there is no conferment. In that case, my lord, the parties coming from that area can go to district council. State cannot say that they can go to session court, since there is no conferment. But they are, my lord,
notification with regard to the DSGS of that district.
Yes. So in that case, my lord, the stand taken by the government to that extent is not the neighbor in that case, since there is no conferment. And subsequent, my lord, the notifications are more or less the same. 2020, the last 2020 notifications. So therefore, my humble submission is this, that the judgment rendered in the convergent case is directly run contrary to the Solembao judgment.
And the
Solembao case. Solembao. And if my lordship may take the Solembao judgment, I will not invite lordship to take the pain to go through the entire judgment of the convergent case where learned AG has taken the pain last time to go through. But I will take the affidavit filed by the state There they have annexed the Solomeo judgment also. My lord. State affidavit filed on 6th September 2023. Commercial judgment. My lord, no, this Solomeo judgment. Solomeo. The reported one or just the? My lord, this is a reported one. The state has an reported one.
Reported.
Yeah.
It's part of my counter affidavit also reported, General Milord, for the sake of convenience.
No, but the one is the one annex. I think is that.
It's a reported, Milord, 2023 SEC page 72 of my counter affidavit.
2023.
72, page 72 of counter affidavit, Milord. R5. In the lead matter.
Page 32?
72, Milord. 72.
Annexure R. Yes. Yes. Well, the fact of the case involved in that Solomeo case is that the FIR was lodged by the officer in charge in Nostoi under 302. And the investigation started, and they found a dead body, and the dead body happened to be the tribal. The prosecution started, and the accused, Mr. Solomeo, moved application before this court to transfer the case, relying on that 2017 notification. Since the conformity is there, it should be transferred to district council. State resisted that one, and this honorable court accepted the application, transferred the case to district council. State found agree, and they traveled to Supreme Court. And the basic argument of the state before the Supreme Court, they did not deny this conformity of 2017. They accepted. They say that the IO, the officer in charge, who happened to be a local, the tribal, but he is performing the official duty. So therefore, complainant cannot be considered as a tribal. He is part of the state machinery. So tribal is one of the parties, not a tribe. Second leg of contention is that, my lord, the victim woman, my lord, she is already normal. And therefore, a dead person cannot be a party. Therefore, she cannot be considered as a tribe. And therefore, the normal session court has the power to try the case. Now, the Supreme Court, my lord, reading both comparative paragraph 4 and 5. Supreme Court indeed read paragraph 4 and 5 together. And Lordship kindly see the, I will take the 11th portion. My lord may come to para 6, my lord, page number 75. It says, my lord, upon considering the material on record and the arguments advanced by the parties, the central issue that arises for our consideration is whether the criminal case against the respondent is Mr. Solomeo, is exclusively trialable by the District Council Court, having regard to the scheme and language of paragraph 4 and 5 of the 6th schedule to Constitution of India. Before we delve into the provision of the 6th schedule, it is to be noted that the session court, before which the respondent was facing trial, is a court established and functioning under the provision of the Code of CRPC. Notably, subsection 2 of the CRPC provides that the court has no application to tribal areas. At the same time, it gives the state government the power to extend the operation of census. So the procedure was quoted. May I come to, my lord, the para 9.
So may kindly see 7.1 also.
Sorry, I can, my lordship permission. As seen above, the expression tribal areas occurring in section 1 CRPC refer to the areas indicated in the 5th and 6th schedules of the Constitution. In the absence of a notification by the state government extending the CRPC to such areas, except the 3 chapters referred to above, the provisions of the CRPC are not applicable to the tribal areas in the state of Meghalaya, including the Kasils district. Now, even my lord may allow me to pause here, my lord. Here, even if CRPC is applicable, the power of a district council officer under paragraph 4 and 5 cannot be taken away by the government. Lordship is very much aware. So mere application of CRPC do not denote the confer judicial office of district council to try cases. Now may I come down, para 9. In the instant case, in exercise of power under some such of the 6th Schedule Constitution, the Khasi Hills Autonomous, Chinte Hills Autonomous District Administrative Justice Rule 1953 were adopted. Rule 9 hereunder provides for the constitution of the one district council court for the Khasi Hills Autonomous District and for the appointment of judges thereto. In exercise of such power under such, a notification was published on such, by which the governor of Meghalaya appointed an additional judge to the district council court, Shillong, and to confer her with powers for the trial of offences punishable with death, transportation for life, or imprisonment for a term of not less than 5 years, and the IPC or any other law applicable in the Khasi Hills Autonomous District Council. In the light of the such specific conferment powers on the district council, Shillong, the issue to be examined is whether the jurisdiction to try the case against the respondent rests solely with the district council court. As mentioned, subpara may come to 10.2. In view of this, we look to the argument raised by the petitioner that the term case as used in para 4 of the 6th Schedule precludes criminal cases merely because the state is the de jure complainant in all such cases. It appears that their interpretation suggests that para 4 of Schedule 6 does not comprehend trial of criminal cases by the district council court at all. This, however, is not supported by the scheme of the Schedule 6, especially when a conjoint reading of para 4 and 5 is undertaken. As mentioned supra, para 4 itself refers to suits and cases to which provision of para 5.1 apply. Thus, to examine the content of suits and cases under sunset, it is first necessary to look to the content of para 5.1. Under para 5.1, the governor is invested with the power to confer the district or regional council or the court set up by the district council or any officer appointed by the governor in that behalf, such power under the CRPC or CPC as he deems appropriate for the trial of certain suits, cases, and offences. The conferrer of powers under the CRPC in certain instances, as has been done by the notifications and such here, makes it amply clear the district council court has jurisdiction to entertain criminal cases, notwithstanding the fact that the state is the de jure complainant in such cases and cannot be considered as tribal party. In fact, it is reflective of an intention as to ascribe a broad meaning to the term case under sunset. Such a reading of the term case is also substantiated by the fact that para 5 only empowers the governor to make the CRPC applicable to those cases where the punishment for the offence is not less than 5 years under the IPC. By necessary implication, then, the governor is not authorized to invest any of the parties mentioned in para 5.1 with the powers under CRPC for the offences where the punishment is less than 5 years. Reading para 5 in conjunction with para 4 inevitably leads to the conclusion that all such criminal cases are trialable by the courts constituted under para 4 of the Schedule 6, irrespective of the fact that the de jure complainant is a state, as long as both the accused and the victim of the offence belong to the same schedule tribe. Thus, in our considered view, the term case does not preclude criminal cases merely because the state is a party to such cases. Upon a close reading of para 5 and 4 of the Schedule 6, it becomes clear that the reference to suits and cases between the parties, all of whom belong to scheduled tribes, was in fact to the affected party, victim complainant, and the accused party. In the instant case, it is an admitted position that the victim and the accused respondent both belong to Khasi scheduled tribe. Thus, given that there is a specific notification since 2017 that confers the district council court with the power under CRPC to try certain criminal offences, we find that such conferrer should be given effect. In fact, upon a combined reading of the para 4 and 5 Schedule 6, such a district council has the exclusive jurisdiction to entertain such a case. So the state contention was upheld, and in view of the conferment of 2017, and that conferment is not only with regard to East Khasi Hills or West Khasi Hills, my lord. So came from those West Khasi Hills. But conferment is for the entire territory of the council. Therefore, Supreme Court judgment cannot be read within the confines of the West Khasi Hills. But it can be read with the entire scope of the conferment is with regard to entire territory of the district council.
So basically, what you're saying, the one power that has been conferred,
yes,
that means is to the it's exclusive.
Exclusive.
To the exclusion of every other parallel forum.
Yes, my lord. And until
that's only done Khasi Hills only.
Yes.
And Garhil Sona above 7 years, no power. Only
no power.
7 years, 5 years ago.
My lord is correct.
Yes.
So until always governor would.
Now I want to show that, yes, Anuj, you're submitting?
My lord, no, governor, until unless governor revoke his conferment,
then the law will operate.
But exclusive jurisdiction is still vested with the presiding judicial officer of the district council. And therefore, the transfer application is they never invoked. That is one thing. And second, my lord, they have taken the.
Now, one thing, conferment of power to try will mean the entire trial or only the last stage.
But
you see what happens, suppose the person is arrested.
Well,
he's produced before the magistrate, then sessions tribal, then it's taken before the sessions judge. Now for bail and all, there's no power with the district council courts, only the power to try. But that is one thing also which has been in my mind. You know, that power to try means like, why can't they have for production, then why is it like that? You know, in the course of before the trial commences, I'm talking about the sessions trial commences, you know, or the procedure before that. You know, he's incarcerated, now bail moved, all those things are going on. Now, why it's only at that trial will mean what? Only the final part.
My humble opinion is, my lord, trial would include district council will have the power to even production.
To
entertain the production, bail matter or production of the accused person during the entire investigation process. Because the investigation is still in the hand of the prosecution.
Exactly. That's the thing. So that is one aspect which. And what do you say, Mr. Advocate General?
Yes, my lord.
Trial will mean what?
Trial,
the last part.
Because this trial, what is trial, my lord, has been subject to a number of case laws in Supreme Court. Because in cases where the cases are tried by session judge, so the trial of those cases takes place. First, cognizance is taken by the magistrate, first class, and then thereafter the matter takes place. And at
the process also.
Process
is still at the stage of the we come to session judge, you know, issuance of production, then appeal of witnesses and all.
Yes, my lord. So there are two stages. One, before taking cognizance and transferring it to session judge for trial. Now, so far as applying that to aspects of criminal trial to the present case is concerned, in paragraph 5, the conferment is in those cases where punishment is more than 5 years, death sentence or life imprisonment. So that class of cases will be tried in terms of paragraph 5.
Right.
So paragraph 5. Within that, because for example, the regular district courts or regular magistrate will not be, because their jurisdiction is separate, district council jurisdiction is separate. So in case of application of CRPC, my lord, because CRPC has been applied in the state of Meghalaya,
yes.
and once CRPC has been applied, the trial has to take place in terms of CRPC provision. So CRPC contemplates two stages of trial of heinous offences. One, before taking cognizance, production warrant, etc., before the first class judicial magistrate, and second stage after cognizance, my lord. So once CRPC is applied, though strictly speaking, the production of accused, etc., will not be treated as trial in criminal law, in criminal jurisprudence, because that trial has not commenced. Charge sheet will be filed, cognizance will be taken. All those stages will happen only when matter is transmitted to the court of learned district and session judge, my lord. So, but having regard to unique situation which we are having in Meghalaya or in terms of 6th schedule.
So after entire process over, first part, then only the last part when it comes to.
No, so the trial in this here, your lordship will have to construe trial means everything right from beginning, whether before district council court or before the regular district and session judge. Because if we bifurcate the certain part of CRPC before the first class magistrate, then first class magistrate is not subject to the district council court. Is a separate hierarchy is there. So far as a district council court is concerned, then district council court they will have to have separate hierarchy because trial has to take place as per CRPC. Procedure is there throughout the state of Meghalaya, because there also they will apply for production warrant. They will also file charge sheet, supplementary charge sheet, section 173A.
CRPC throughout. Yes.
Yes, so once CRPC is applied, the principle will.
One you put a spin into the entire process again.
So then, no, in this case, my lord, what my friend is arguing is this, that the judgment.
I understand. This is just the.
No, I understand, my lord. So
this coming in now. What about the pre-trial process?
No, even that will, in my submission, that will, if your lordship construe the district council court has the jurisdiction, even that will go to the district council. There I agree with my friend on that point.
Yes.
Everything.
It have to go.
It has to go because in heinous offences where the punishment is more than 5 years, jurisdiction will be exclusively on district council. If the plea of my friend is accepted, but what I can show that that plea is without a.
No, that's the difference. That was the main meat of the matter.
Yes, ma'am.
What I'm saying only with regard to the process.
The process will also go to either of the. It will go before district and session judge, my lord. The court constituted under the CRPC, my lord, first class magistrate.
So one is cognizable by sessions court. That means it should go there straight.
Straight.
Wherever cognizance is taken.
Yes, my lord, because wherever the cognizance is taken. That is the scheme of the CRPC.
That is the scheme of the CRPC.
That is the scheme.
That is what.
That's the scheme of the CRPC.
So then it comes in conflict with paragraph 5(1).
And paragraph 5 and what my friend is submitting.
Autonomous situation.
Yes.
Well, but then if we decide that yes, under 5(1), on being conferred, all these cases are exclusively triable, but it's constable, then even the other processes in view of the application CRPC also should necessarily go there.
Should go to district council.
Yes, and even matters of applying for bail or discharge of some, all those things.
Because the para 5 did not classify the power of the trial. HE has clearly pointed out.
Yes, it just confers the power.
Confers the
power. Power means it has to go lock, stock, and barrel.
Exactly. But from the day one of the rolling up the criminal prosecution till the end,
with application CRPC, then we will not go there. I think better not open. Can of worms.
Madam, the issue, my lord, since the matter here is a very important, it becomes a constitutional issue. It's a far-reaching consequences.
Regarding?
Far-reaching consequences, this. Many cases are pending. My lord, even the issue today here regarding transfer, many cases are pending. Many parties waiting to go to district council. Now, many parties pending to district council are in confusion whether I'm rightly prosecuted before the right forum or I need to go to session court. And it is very important. Therefore, now, if I invite my lord,
consideration which the state has, and which also, I mean, just talking off the record in the Administration of Justice, which we now High Court at the helm. Now, with regard to the pendency and the time is taken for these sessions trial to complete. Now, what is dragging the entire bring up the pendency, and especially in the number of years, cases have been pending for 10, 15, 20 years. Now, the matters of pendency council are dragging the entire graph of the state down. Now we have equipped, the things that talk about from private aspect, established district session judge establishments in all the districts. And so, which are qualified and eminently, competent to handle this thing. Now, district council court, apart from being like a logistical deadlock to, the litigants, whatever who come and conduct cases here, I'm not come up here. Now it's the pendency, the pendency of these cases has created a severe, that is, to my mind, not saying that I'm not talking about the law, I'm talking about the Administration justice aspect. It's created, where people don't see justice. Some people are just, the cases hang over their head. And so it's become and if it goes to the council, some people who are accused are happy, because they thought maybe in the entire duration of their life, that case, just by the time it comes for the witnesses appear, they're not there anymore, they can't remember anymore, it ends up in acquittal. So that's the thing. So in the spirit of
yes,
I don't know.
But that is the.
But that's the thing. But frankly speaking, this pendency of the cases council, which is a huge burden,
yes,
is bringing down the entire, the graph of the disposal rate. Especially old cases of serious concern. You can't have cases from 89 still pending.
Yes.
85 still pending. See, that is
one of the concerns. Lordship has correctly pointed out.
And that is a concern, but we have to.
Yes.
Law has to be applied. Law,
right,
whatever it is. Yes.
Opinion of the learned members of the bar was divided, and Lordship one view of the members of the bar is, yes, pendency in the district council level is definitely inordinate. Another view of the members of the bar is, similarly from the normal judicial side also, there is no effective adjudication. Be that as it may, but the positive step taken by the district council as of now is they are appointing judicial officer. Many judicial officers have been appointed, and court has been established in different districts. This is, in my opinion, my lord, is a positive direction to remove those pendency of cases and expeditious
The thing is that
delivery.
they are burdened, mostly of, especially civil matters now, they are just held up.
Yes.
And so a lot of people, there will let a lot of complaints also.
Yes, that is
with regard to cases in reserve for judgment for 7, 8, 9 years.
Well,
those
in fact,
things are
right.
those are really of grave concern.
If I'm not mistaken,
and in fact,
my
the
lord.
Supreme Court now has a committee headed by a senior judge and 2 other judges, and which we have to sit for each one of them. And so they asked us to put, case delay management, sort of a scheme.
Yes.
How to manage delay. Right. So all the judicial officers are asked to earmark the cases, take out the cases which are above 5, 10 years, how many witnesses, all those things. That is a formula. But then, for us, we don't exercise jurisdiction to the council courts where the maximum pendency is there. How do you reply? But then in the system, it reflects. The CS system, because they upload also. So undated cases go, cases which are pending without any dates, cases where no orders have been passed for years. So that is also that it's, it becomes very difficult.
It's a great concern.
And so if we're thinking about litigants as a whole, we have to have some more efficiency. Anyway, yes, please continue. That's just digressing. But that is the only thing, but I think the CRPC applicability, the trial and all, yes. Yes.
With lordship permission, may I invite the stand taken by the government in paragraph 17 and 18 of the affidavit. Now, with regard to Solong Pao case, paragraph 17 of the counter, state counter.
Paragraph
17 of the counter, page number 8. They say that Solong Pao judgment is not applicable in this transfer application, and they do admit, page 9, the continuation of paragraph 17. It says, my lord, in the middle, as a matter of fact, the factum of the notification, that is my 2018 notification, issued by the state government under paragraph 5.1 of the Constitution conferring power of district and session judge were inadvertently not brought to the notice of the Honorable Supreme Court. And the Honorable Supreme Court, on the basis of the material, that is notification 2017, came to the conclusion that the power to try cases under paragraph 5 has been conferred to District Council Court. Therefore, the judgment of the Honorable Supreme Court of, in the state of Meghalaya versus Solong Pao are clearly distinguishable and not applicable. But may I submit, the state appeal, this is a state appeal for Supreme Court. If, my lord, they found that they failed to produce the relevant notification, they could have filed a review application brought before the Supreme Court, the latest notification 2018, and reconsider the matter. But despite of that, they did not do this. And the parallel notifications are there. And whereas Supreme Court has given in the judgment in 2017. So 2017 will definitely, my lord, endorsed by the Supreme Court. That will hold the field, my lord. Hold the field, my lord. And say other paragraph, they have taken para 18. Para 19 may I take. Para 19. It is submitted that the fact situation has been changed in as much as state government wide notification 2022 has extended CRPC to the courts in the state of Meghalaya. In view of the extension of CRPC to the court of Meghalaya and coupled with the fact that under the existing constitutional provision of rules for administrative justice, Sons 37, and also having saving clause in the notification, the trial of cases by district and session judge for offences punishable, imprisonment for a term of no less than 5 years is well within the jurisdiction. My lord, may I take their notification of 2022, page number 79, the last page of the counter affidavit. In the middle of notification, my lord, they say the district
continue to derive powers.
Yes.
That part, yes.
That part is very clear.
Court notice earlier on also.
My lord, my humble submission, my lord, the application of CRPC in the tribal area never takes away the power of the district council court deriving from para 4 or para 7. So long as para 7 is para 5.1, so long as para 5.1 conforming is there, district council court continue to enjoy, my lord, unless governor revoke it. So by new application of CRPC, procedural law, will not, my lord, strip off the power of the district council. And therefore, since the notification is 2007 notification, the 17 notification is there, the transfer application which we have.
Now, how do you interpret this as a council court? I understand also, I've read this many times. So can you derive powers under paragraph 4 and 5? That means derive power to the existence or the exercise.
My lord, at the time of issuance of
the existence means courts considered under paragraph 4. Now, the existence or the exercise of powers, what is that? That means can you derive powers that continue to exist by virtue of paragraph 4 and 5?
Madam, in fact, my lord, this is not even required to be incorporated in the notification. Governor has nothing to say about this.
No, because it's
because the sixth schedule.
No, because section part of the constitution, notification can't, seek to, can't take with the powers vested by the constitution. Yes.
This notification cannot override.
Cannot take away the powers. Yes.
It cannot override, cannot take away. Cannot take away. And if we read, my lord, the paragraph 5 of 6th schedule, rather it is clearly say that CRPC is not applicable, shall not be applicable to tribal areas. May I just lordship, then invite lordship.
Has anyone challenged notification as yet?
My lord,
no. As I submitted earlier, the district council, though at a very late stage, has challenged the Commercian judgment before the apex court, primarily because of what my friend has said, has drawn your lordship's attention to para 5.3. Para 5.3,
yes.
Which one?
Thank you.
5.3 is a save as expressly provided in this paragraph.
Yes.
Save as expressly provided in this paragraph, the Code of Civil Procedure and the Code of Criminal Procedure shall not apply to the trial of any suits, cases, or offences in an autonomous district or in any autonomous region to which the provisions of this paragraph apply. So, para 5.3 of the Constitution of 6th Schedule says that the CPC and CRPC cannot be applied to the autonomous district. My lordship is well aware, apart from the 3 wards of Shillong, the entire Meghalaya is an autonomous district.
Amendment 6 schedule will has this happening to say about unfair justice. Amendment that's coming out very soon.
My lord, this issue was dealt in the case of Longsan, Hongai, which has been reflected in Solong Piau's case also, relied upon. Very interestingly, my lord, this was only today morning when I was reading this Longsan. I came across title. This is let us come to para 3. Courts are established for trial of offences created either under the Indian IPC or under the various laws made by Parliament or the appropriate state legislature under the provisions of the Code of Criminal Procedure 1973 or under some other law made by either the Parliament or the appropriate state legislature. It is not in dispute that the fast-track court before which the petitioner is facing trial is a court established and functioning under the provisions of this Code of Criminal Procedure by virtue of the declaration made under Section 1 of Subsection 2 of the CRPC. The Code of Criminal Procedure has no application to the tribal areas except chapters 8, 10 and 11, which are not relevant for the present purpose. However, the appropriate state government is authorized to extend the operation of the CRPC to the tribal areas, Section 1 of so-and-so. But the section authorizes the government to extend the provisions of the code to the tribal areas. But the concerned state government may, by notification, apply such provisions or any of them to the whole or part of the state of Nagaland or such tribal areas as the case may be, with such supplemental incidental or consequential modifications as may be specified in the notification. And my lord, this is interesting. A provision of doubtful legal efficacy in view of the prohibition contained in paragraph 5.3 of the 6th schedule, but we do not wish to record any final conclusion on this question, as no arguments in this regards are advanced. So, my lord, what has happened now? The notification of 2022 is, in my submission, is against the paragraph 5.3. Now, my lord, will come to paragraph 12A. It is only the president who can 12A of the 6th schedule. So that's why the district council has approached the Supreme Court, challenging the notification of 2022, saying that the state government does not have the power to apply CRPC or CPC in view of paragraph 5.3. It is only under 12A. Let us come to 12A. Application of acts of parliament and of the legislature of the state of Meghalaya to the autonomous districts and autonomous regions in the state of Meghalaya. Notwithstanding anything in this constitution, if any provision of law made by a district or regional council in the state of Meghalaya with respect to any matters specified in sub-para 1 of para 3 of this schedule, or if any provision of any regulation made by a district council or a regional council in that state under paragraph 8 or paragraph 10 of this schedule is repugnant to any provision of a law made by the legislature of the state of Meghalaya with respect to the matter, then the law or regulation made by the district council, or as the case may be, the regional council, whether made before or after the law made by the legislature of the state of Meghalaya, shall to the extent of repugnancy be void, and the law made by the legislature of the state of Meghalaya shall prevail. Now B, the President may, with respect to any act of parliament, by notification, direct that it shall not apply to an autonomous district or an autonomous region in the state of Meghalaya, or shall apply to such district or region or any part thereof, subject to such exceptions or modifications as may specify in the notification, and any such direction may be given so as to have retrospective effect. So that aspect of the matter also, although it's not an issue before my lord in these particular cases. Now the notification under 22 also, that the government has the power in view of 5.3. Because 5.3, the constitution will prevail over any other statute. Now 5.3 has said that the CPC and CRPC shall not be applicable in the autonomous regions.
I remember the judgment also, because
yes,
when there was a matter we'd gone for admission to Supreme Court, this is Chairman Forum was sitting.
Yes.
And he was talking about the judgment that Westerly.
Westerly, yes.
That, yes, that case
applicability of yes.
Yes.
And also would appear in that matter, yes. So right, even then in Longsan case also the.
No, but then, but the thing is that it just skirts the issue. It has not touched it.
It has not touched the issue, but
it's a been observation.
Yes.
But the thing is that yes, now saving of powers, we do not. The notification does not need to save
question of
powers.
saving powers also does not arise
Because the
our powers is conferred by the Constitution by 5.3, 5.1.
And we only have to distinguish. This whole thing can be avoided only if the governors need to confer power under 5.1.
Yes, that is
so that's the thing. So why, if they want, they're interested in disposal and all, they should,
withdraw
the powers.
Or don't give the powers.
And it'll be, and the district council courts, their arms will be freer to, do civil matters more effectively.
In fact, Lordship, even after the case of what? Commercial case, 2 additional judge and the judge also have been conferred powers.
Yes. So it's become
Under 5.1. Yes, we want to solve this issue because it's becoming a.
No, because litigants are suffering also. That's the only thing. And also the accused, they want to go to the council court because the process is very long. But it was a very interesting case once because it was after discharge or acquittal from the by the district council courts, an application was filed in the High Court, then asking that that for the challenging that order, and it was retried and taken to fast track court. And in the fast track court, one of the accused was sentenced. And so those are the things also that, but that doesn't receive much attention. But that also is an aberration, in the process. You ask for retrial on certain things. If it goes back on certain issues, then why should it go to the, to the fast track court and not go back to the court and chat? Yes. So that's the thing.
Anyway, I just wanted to draw your attention to 5.3.
The schedule throws up, it's still, we might have been in the profession for many years, but every time it throws, it's still, most of it's still grey.
In fact, that's what I said in the morning when I read
It's always still grey. Everything, my seniors would say, like, still, you might practice 50 years schedule, but a lot of grey areas still is. It's a very interesting piece of legislation. That's the thing. It gives lawyers a lot of place to slip and slide and interpret. Yes. Yes, Mr. Chandraso. Now we've lost track of where you argument.
But I also conclude my submission, my lord. So my humble submission is the application for transfer will be entertained in view of the fact that my Supreme Court judgment holds the appeal, and the fact that my lord, the contention raised by the state that the notification of 2018 is applicable is not correct, in view of the fact that my lord, such notification is even not there in the remaining districts. So
Yes,
that
you're saying that, yes, for West Cast Hills is not there.
West Cast Hills, South West Cast Hills, my lord, it is not there. And one of the transfer application to the number 3, Representative Mr. Prabhu Chate.
Who's of hearing?
Number 3, item number? What is item number?
39.
Yes. 39. Item number 39, the cost is today. This is from the West Cast Hills. My lord, in the West Cast Hills District and Session Judgment, there is no such confirmation to a district and session judge. So therefore, the argument is.
Then I think you do one thing, segregate these matters. Where is conferment on the district session judge, where is no conferment?
Yes.
Then they'll have to be different. I have a good mind to refer this to a larger bench, because it's I think, but larger bench also means.
I think Justice Dingo has already.
Yes.
No, has he been part of no?
No, he's part of
Commercial.
Justice Dingo.
Why don't we even refer to larger bench? Whenever appropriate bench available, maybe.
No, then the matters are just stuck up also. We can't, one thing this court understands from the way that we can't oversimplify the matter also. You still find notifications there. Now you can current powers, you go. Now we can't oversimplify it also. It needs some, what do you call it? Discussion.
No, finality is required, my lord, in these matters, because, for example, in first matter, my lord, say rape, case of rape, 13 witnesses have already been examined.
Which case?
The first transfer matter, 13 witnesses have already been examined, my lord, and the accused is.
That is a whole problem.
And only 2 witnesses are left. And if I can if my friend concludes his argument, in only 15 minutes I will show that no case is made out for transfer. Only 15 minutes by watch, my lord. I will show, because what is being argued before your lordship, what is the ground which is being taken? One ground which is taken, if I have to simplify the grounds, I understand. One ground is taken that there is a conferment on district council courts. Therefore, after conferment, they have got exclusive jurisdiction. That is the first ground. And therefore, the regular district and session judge has no jurisdiction even after notification issued by CRPC. That is the first ground, if I have understood.
Yes.
For that, the judgment of the Supreme Court in Solan is being relied on. This is the 2 arguments which have come out, my lord. There is no challenge to the CRPC notification, my lord. There is no challenge as on today. There is no challenge to the law laid down by the division bench of this court in commercial. And that can't be challenged also, my lord, and that law is...
No, that is the only problem this court is having, in spite of,
No, so then your
one
lordship...
thing, Mr. Arjun, I mean, personally, I can say I'm aware, I'm bound with the division bench judgment.
Yes.
That's the only thing that...
No, that is a second...
That's why I say, why should I refer to the larger
Your
bench?
lordship-
There are some questions which there are no answers as yet.
And in my humble submission, my lord, every question has been answered. What is the question which is being raised before your lordship? Question is that there is a notification issued by the state government in paragraph 5 conferring jurisdiction on the district council court. Therefore, they have right to seek transfer from district and session judge to the district council court. That is the only question which is there before your lordship.
Right.
There is no other question to my understanding. Their only question is that there is a conformant. The question in my humble submission would be, or the question should be, whether the district and session judge which is trying the cases has the jurisdiction to try those cases or not. If the district and session judge has the jurisdiction to try the cases, then they can try the cases. If the district and session judge lacks jurisdiction, then only the cases can be transferred, my lord. And the argument which is being taken for transferring...
Now, West Khasi Hills, that's the only thing. Now no confirming there.
No, conformant or no, I'm not going into the conformant, my lord. I'm going in the first step. First step, whether the district and session judges of Meghalaya have jurisdiction to try the cases, criminal cases, where the sentence is more than 5 years. If they have the jurisdiction, my lord, whether I give conformant, in Garo Hills, my friend has said there is no conformant. In Jantia Hills, there is no conformant. In Khasi Hills, there is a conformant. So the ultimately argument comes down to the issue that by issuing conformant, the district and session judge, regular district and session judge are denuded of power under CRPC. They do not have power because there is a conformant on district council court.
No, they are deriving the power from this constitution.
And first, they are deriving the power from the constitution.
Yes.
Second, they are deriving the power from the CRPC. The only question which should be there before your lordship is whether because you can seek transfer from one court to the other court in any principle of law, is that the court which is not having jurisdiction.
Not jurisdiction. Yeah.
Jurisdiction. If that court is first, because there is no argument advanced in half an hour, 1 hour, that the district and session judge has no jurisdiction. Because they can't argue this point because constitutional power, your lordship has rightly said, under Article 233, district court has been set up by, under the constitution. Then they rely on the Solan judgment to say that in Solan judgment, conformant was there, so therefore the district council has the jurisdiction. That judgment clearly says that in absence of paragraph 7.1, your lordship has seen, in absence of notification by CRPC, and CRPC was notified in respect of 3 chapters, and then this Honorable Supreme Court goes into those 3 chapters to say that in these 3 chapters, only these kind of cases can be tried. So ratio of that the judgment is that if CRPC is notified, regular district and session judge will have jurisdiction.
Right. Right. So what about parallel jurisdiction then?
Now that question is right now, whether that question is before your lordship, whether they have, because question is of transfer before your lordship.
Okay, but then the thing,
and then that is a legal
question is there. The larger question is that we can't just, turn a blind eye.
No, your lordships, on administrative side, those issues can be addressed, my lord. I see what is falling. On administrative side, those issues can be addressed, my lord. But on judicial side, the only legal issue, because your lordship, we are raising the issue with the district and session judge has no power. My friend is raising, and
that's the brass tacks. And the baseline is what? Baseline is this court sitting here.
Yes.
In a single bench.
Yes, my lord.
Is looking to distinguish commercial judgment because
I'm not going into commercial judgment also.
We are bound by it also.
Yes, my lord.
That's the thing.
That is an additional point.
Whether I like it or not.
Yes, my lord.
That is the additional demands that I'm bound by it. So that's why we have to look for something else.
Yeah, because your lordship will differ. Your lordship will differ with commercial judgment or find something is not referred to or relied upon. Then only your lordship will refer it to that this issue require, and that too, the reference cannot be by learned single judge of the division bench judgment. Because reference will be of the coordinate bench only.
Right.
Reference will be of the coordinate bench.
Not reference, it's a place it before a larger bench.
No, even that is because larger bench, the reference will also be by, because if the learned single judge will start referring the matter to the larger bench.
No, it wasn't a question. Larger bench is a question. See, the thing that there was a
that
matter also,
proceeding is
regarding that Order 6 of District Council that I placed it, I referred it to a larger bench. It was taken out.
There also I can render.
Didn't accept my findings, but
Your Lordship, there is also judgment on that aspect. Then in what situation, in what manner the learned single judge can refer the question to the land? Because in Supreme Court also, this issue has been, Your Lordship is aware, 2 judges bench referring to the 5 judges bench, and then ultimately, so then law came to be settled in those matters, and then in some matters, because as a matter of judicial propriety, what happens if that issue, because that issue, I will refer it to larger bench if I see that particular point has not been considered and that judgment is having some ramification. So therefore, the
only point out here that the Solong Pio was not considered as right perspective.
No, and why?
That is what.
No, so,
that is the
now for that also, my lord, kindly see.
If it is a ruling of the Supreme Court, it has.
Whether it is applicable, like I put in, if it is not applicable, it was not applicable. That is why it was not cited. Why it was not applicable, my lord? My friend is why it was not applicable for 2 reasons. One, CRPC notification was the basis of that judgment, my lord. Solemn judgment was based on, and second, there was no in Rivoi district, my lord. There is a conformment under 1937 rules. In solemn judgment, there was no such conformment which was placed before the Supreme Court. And so there are 2 bases of the judgment of Supreme Court. Supreme Court says CRPC has not been extended, and Supreme Court examines that CRPC only 3 chapters are extended. Therefore, in 3 chapters, trial before district and session judge cannot take place. That is what, and in commercial judgment, my lord, clearly 2 issues have been taken into consideration. There is that under 1937 rules, conformment is there. And what Justice Banerjee read into that commercial judgment because Justice Banerjee said that in paragraph 5, you confer the power on the district council court, or you can confer the power on any authority, because that the conformity. Conformity. So that is how district and session judge of Rivoi Nongpo was conferred with the power. To that extent, Justice Banerjee read that power the district council could, because it is in supersession of the conferment power. That detailed discussion after considering paragraph 4, 5, rules, everything, nothing. So Solan pure judgment was not referred by my friend, knowing that it is not applicable, my lord. Now it is a new ingenious argument which is being advanced. That judgment was not placed before the division bench. Therefore, that is not a good law. If that judgment is not relevant, my lord, if I have to distinguish a judgment on this ground that there are 10 judgments which are not on the issue, and I do not refer, and then I say ingeniously that judgment was not referred, so therefore please refer it to the larger bench. In my humble submission, my lord, that is not the rule of law. Rule of law is that there is a judgment which covers the field. Even Solan judgment is in my favor. That is why I have annexed that judgment in my counter affidavit, showing that judgment clearly says that in absence of CRPC notification. Once CRPC notification is there, my lord, things have changed. Even Ratan Singh judgment I have placed for that purpose along with my counter.
Of course, things have changed. It brings a whole dimension.
A whole dimension has changed. Whole dimension has changed. And then, Your Lordship, the only question, because Your Lordship, is parallel jurisdiction issue is also troubling me, that unnecessary confusion, and we keep, in fact, I have advised them also that we have to streamline the process, because ultimately we are here to provide justice to those who go to the courts and they get the expeditious justice, not for the lawyers, not for us. And if they are not getting expeditious justice, because what is the prejudice which is being caused to my friend?
It's only going to favor the accused.
It is favoring the accused, my lord, ultimately.
So
And
naturally,
and we
expect
have
an
to think.
advocate to take advantage of.
And we have to think of the victim also. Ultimately, we have to think of the victim also. And victim is, and here the simple issue is, my lord, in my humble submission, is the plain and simple issue which is there. They have to show that district and session judge is wholly without jurisdiction.
Yes, that is important.
And if they do not show that there is no jurisdiction, they cannot seek transfer. The only basis for seeking jurisdiction is that there is a notification under paragraph 5 on district council code. Therefore, district and session judge is denuded of his power. It's not correct, my lord. So that
So your main argument is that
yes,
with the application of CRPC, everything is rendered.
Everything is because the CRPC does what, my lord? It confers the power and
so you said with application to CRPC
power and power, and even I have got 4 supplementary arguments on that. One is that first argument is that the conferment, the CRPC extension of CRPC notification means regular and district and session judge has power to try the cases, even between two tribunals. Yes. This is second argument is that the district judge has been created under the power of constitution under Article 233. My notification under paragraph 5, because paragraph 5 is not giving original jurisdiction on the district council code. Paragraph 5 is not giving power to the district council code. It is only by virtue of it is an enabling clause, enabling provision. Even paragraph 5 itself will not confer power on the, your lordship has rightly put and succinctly put that issue, that by putting that in the notification that continue to derive the power is only reaffirmation of the constitutional provision.
Yes.
It is only reaffirmation of the constitutional provision to clear the doubt in the minds of the people that by CRPC the power of district council is being taken away.
No, exactly to show that it still exists.
They will
what they exercise the power.
No, exercise is power only by conferment. Now, assuming
that's exactly the same thing. Existence, one thing.
Yes,
they derive the powers from 4 and 5.
Yes,
but the exercise the powers now, how has that changed?
Yes,
that's
the only issue. That's the only issue which your lordship has to. And there, my endeavor would be to assist your lordship on point 1, saying that the district council, because first duty to show, my duty will be so that if there is no power, because first they are selling the jurisdiction of district council, they are selling the jurisdiction of district and session judge to try those cases. So they have to show that they do not have jurisdiction. If they prima facie show something that they do not have jurisdiction, and in view of the constitutional provision, in view of the CRPC extension, CRPC applicability, my lord, in view of 1937 rules also, under which, under the 1937 rules, my lord, the justice, rules of justice in administration of rules of justice, that was being used and invoked time to time, my lord. So therefore, it is not a case of complete lack of inherent jurisdiction in the district and county, because in certain cases, my lord, like writ petition and civil suit also, there is a parallel jurisdiction. The party can go to the civil court, party can come before your lordship also. But that will not, if party is coming or aggrieved party is coming before your lordship, that would not mean that the civil court has no jurisdiction to try those cases. Yes, it is causing some difficulties on the administrative side. This is causing some confusion, which has to be addressed. But that cannot be a ground to say that district and session judge has no power to try the cases. Only ground they have to show, only thing is that once CRPC is there, solemn judgment is there, law is there, trial is taking place efficiently. My lord, if I envisage a situation, my lord, if my friend's argument is accepted, my lord, that then in KHADC area or GHADC or GHADC area, then we will not be required to have, because district and session, once notification is issued, all cases, because 85% population of Meghalaya is tribal, my lord, all cases will go to district council. We do not require huge infrastructure. This infrastructure, the appointment of judges, monitoring of the courts by the Honorable High Court all those are for serving the people so that they can get immediate and efficient justice. So even in public interest, my lord, your lordship have always weighed public interest in interpreting the provisions of law so that the larger cause of justice is advanced. Larger cause of justice is that the cases are tried efficiently, properly, and in accordance with rule of law. So therefore, it's not a case of lack of inherent jurisdiction. It is not a case of unfair trial which is being meted. It is not a case where the trial is being conducted by outsiders or somebody. They are all from 85% of the judiciary is filled by the people from Meghalaya only.
Yes.
So then they are not getting, so victim as well as accused both are getting justice in the system which is being closely scrutinized by the Honorable High Court. Closely scrutinized, and your lordship has shown that they are the issues which are there in working of the district council courts. And in Garo Hill Autonomous District Council, we do not have district council courts. In those cases, if the argument is accepted, my lord, that even after notification of CRPC, the district and session judge of Garo Hill areas, they do not have jurisdiction, because finding of the law will be common for the entire state. And what my friend is arguing, that by conferment of jurisdiction on the district council, and even after coming of CRPC, the regular district and session judge will have no jurisdiction. Then conferment is overriding the CRPC statutory provision.
No, what is right of preemption, in a way, like that they have first
Yes, in civil,
right.
yes, and preemption is also a weak right. Your lordship knows. Preemption is also a weak right, but here it is a case. Here it is a case of Milord, because everybody has to be tried in accordance with law. Your lordship is concerned. Article 21 gives them, no person shall be deprived of.
No, we're not there. It's fine. We're not saying that they've been given unfair trial or they're not being due opportunity. That's not the only thing. Is
the
that
point
the mechanism.
No, point I was making is that all these powers are coming from the Article 21, which says that no person shall be deprived of life or personal liberty except according to procedure established by law. So what is the procedure established by law, my lord? IPC, CRPC, these are the procedures established by law. Because I am required to be tried in accordance with the procedure established by law, and procedure is CRPC, procedure is IPC, or 1937 Rules of Administration of Justice, or District Council Code.
Yes.
So therefore, in my humble submission, my lord, the District Council Court will not get the right to try those cases merely because some conferment has taken place. And that will not have the effect of taking away the constitutionally ordained right on district and session judge, regular district and session judge, and under the statutory provision of CRPC. My lord, my friend has read the State of Meghalaya versus, kindly see paragraph 7 of this judgment, which is very clear. Because paragraph 7, Solanpio. Melvin Solanpio. Page 75, your lordship.
Yeah, before we delve.
Yes, madam. Before we delve into the provisions of, and your lordship will also keep one aspect in the mind. In this case, the state argued that case does not include criminal cases. Case, the definition of it was not a case, my lord. Unfortunately,
on behalf of state,
State Mr. Mukherjee argued. It is before 2017 judgment. Mr. Ranjan, it is argued by Mr. Ranjan Mukherjee, my lord.
Name not recorded.
Not recorded. But what was the argument of the state is paragraph 4, my lord. paragraph 4, from paragraph 4 it is clear. It is not the ratio on jurisdictional aspect. Relying on these provisions, the learned counsel for petitioner urged that paragraph 4 of the sixth schedule of the Constitution, all the parties to a suit or case must necessarily belong to a scheduled tribe within such areas for district council court to have exclusive jurisdiction over such suits or cases. Given that a criminal case is always prosecuted by a state, he submitted that the instant case against the respondent cannot be said to be dispute between two tribal, as deceased is not and cannot be paid to be party to such a case. He also urged that complainant, the officer in charge at the police station, can also not be considered a party to the case. He may be acting in his official capacity and thus form part of state machinery. So what was argued, my lord, that case and this aspect, my lord, has been considered in paragraph 7.
But how come that case, Richard Dakar was not placed here and this matter was argued?
Paragraph 6.
Anyway.
Paragraph, upon considering the material on record and arguments advanced by the parties, the central issue that arises for our consideration is whether criminal case against respondent is exclusively tried by district court having regard to scheme of paragraph 4 and 5 of the 6th schedule of the Constitution. Before we delve into the provisions of Schedule 6, it is to be noted that session court before which the respondent was facing trial is a court established and functioning under the provision of Code of Criminal Procedure 1973. Notably, subsection 2 of section 1 of CRPC provides that code has no application to tribal areas. At the same time, it gives the state government the power to extend the operation of CRPC to tribal areas as follows, my lord. So, the session where the case was being tried in West Khasiel before session judge was not a session judge established under the CRPC. And 7.1, my lord. Next. As seen above, I will just read that also provision, my lord. It is relevant for that because ultimately 7. Short title and extent and commencement. This act may be called the Code of Criminal Procedure 1973. It extends to whole of India, provided that provisions of this code other than those relating to Chapter 8, 10 and 11 thereof shall not apply to the state of Meghalaya and to the tribal area. So only Chapter 8, 10 and 11 will apply, my lord.
Yes.
But the state government concerned may by notification apply such provisions or any of them to whole or part of the state of Nagaland or such tribal areas as the case may be, with such supplemental, incidental or consequential modification as may be specified in the notification. Explanation. In this section, tribal areas means the territories which immediately before 21st January 1972 were included in the tribal areas of Assam as referred in Part 20 of 6th Schedule to the Constitution, other than those within the local limits of municipality of the Shillong, my lord. As seen above, expression tribal areas occurring in section 1 CRPC refer to the areas indicated in 5th and 6th schedule of the Constitution. In absence of notification by state government extending the CRPC to such areas, except 3 chapters referred above, provisions of CRPC are not applicable to tribal areas in the state of Meghalaya, including Khasiel district. So that is the foundation of this judgment, my lord. And that is why this judgment has no application. And that is why it was not feeble attempt was made to place it, and when it was distinguished, it was never pressed into the argument. Here it would be useful to note Chapter 8 CRPC deals with the security for keeping peace and good behavior, Chapter 12 deals with the maintenance of public order, tranquility, and Chapter 11 deals with the preventive action of the police. Evidently, none of these subjects falling under Chapter 8, 10 and 11 are relevant for the purpose of deciding the matter. Trial before the Court of Session falls under Chapter 18 CRPC, which does not apply to tribal areas in question. So this, my lord, now Chapter 18 applies, and when Chapter 18 applies, my lord, the question of and paragraph 10.2 you also will see on the issue.
Yes.
Paragraph 10.2. What is the ratio of this judgment? Why this judgment was not relevant in commercial, my lord? 10.2. Because Chapter 18 applies, my lord. Paragraph 10. In view of this, when we look to the arguments raised by petitioner, the term case as used in paragraph 4 of Schedule 6 precludes criminal cases. So what was the argument advanced by the state? that cases will not include criminal cases.
Which is a
This is
misplaced argument.
user's argument, sorry to say. Cases merely because the state is de jure complainant in all such cases, it appears that interpretation suggests that paragraph 4 of civil does not complain trial of criminal cases by district council at all. This, however, is not supported by a scheme when a co-enjoined paragraph 4 as mentioned in paragraph. So cases will include criminal cases also. And if this interpretation would have been accepted, that means even for the trial of cases where punishment is less than 5 years, district council court would not have the jurisdiction. So therefore, this judgment, my lord, in greatest respect has no application, my lord. Ratio is what is case in paragraph. What do you mean by case in criminal matters? Whether case will include civil matter only or criminal matter. Supreme Court says that no, case will include civil and criminal, and rightly so.
Yes.
Supreme Court says that you have not extended CRP, so chapter 18 of CRPC is not applicable. So session judge in West Khasi Hill has no power to try the cases. So where has, in my humble submission, Komarchand gone wrong on these issues? Komarchand has considered each and every aspect. And this judgment is not an authority on the proposition.
Not discussed.
Yes, my lord. This judgment is not the authority on the proposition. And if your lordship will see Komarchand, each and every aspect, including 1937 rules, have been considered in detail, extensively for 10-20 days. I don't know, 3 weeks we have argued that matter. And larger issue, my lord, I would urge your lordship, larger issue in administration of justice, my lord. We are not taking away the power, the state or the High Court. Nobody is taking away the power of the district council court. Those powers are very much there. Those powers are there, but ultimately courts are for the betterment of the people so that speedy and efficient justice is given to them. A person who is victim, and then your lordship see kindly Komarchand judgment, my lord.
Yes.
Paragraph 26 onward. Because these notifications which my friend has placed before your lordship, those notifications are notifications. They are not as such laying down law. Law will be laid down by CRPC and the provisions, paragraph 20. Any assessment of doubt.
Yes.
Sorry, my lord. Because so many times. Paragraph 26 onwards, my lord. Any assessment of doubt and issues raised by the appellant herein has to begin with reference to 2 key paragraphs in 6th schedule to the Constitution. There is no doubt that paragraph 4 vests the administration of justice in autonomous district with the district council court, but such authority comes with 2 caveats indicated by expression between the parties, all of whom belong to a scheduled tribe within such area, and other suits and cases to which previous subparagraph 5 apply. The words cases in the second paragraph would take within all matter covered by paragraph 5(1). My lord, that is in the reference of Solon only. Paragraph 5 of the 6th schedule to the Constitution makes a clear distinction between the other criminal matters and criminal matters pertaining to trial of offences with death, transportation for life, or imprisonment for a term of not less than 5 years. In respect of such criminal cases pertaining to offence under penal code or any other law applicable to the relevant district, governor is empowered to specifically confer authority on bodies and persons. My lord, it is not only on district council. On such authority may be conferred on district council having authority over such district, or courts constituted by such district council, or any officer appointed in that behalf by the governor. Because those notifications are conferring power on district and session judge in Ruboi. Since there is no regional council, reference to regional council, the provision is ignored. Last limit of paragraph 5(1) of 6th schedule to the Constitution emphasizes it is only upon the conferment of authority by governor in respect of serious criminal matter that relevant court or official shall try the matters in exercise of power so conferred. In other words, till the authority is conferred in accordance with paragraph 5 of the 6th schedule to the Constitution, such powers cannot be exercised. The only possible interpretations is paragraph 4 of 6th schedule, which apparently confer all powers on village council and district council court, is tempered by excluding from such authority the jurisdiction to try cases suits and cases to which provisions of para 5(1) of schedule apply. On the other hand, authority may be conferred on the relevant district council or courts constituted by district council or any other officer appointed in that behalf by governor. Since it is clear that authority in terms of the relevant provisions may be conferred on the relevant district council or district council court, it needs to be emphasized that such authority may also be conferred on any officer provided that such officer appointed in that behalf by the governor. Ignoring to begin with the authority which is exclusively invoked in issuing the disputed notification, it is evident that in each case authority has been issued to a particular district court, council court, or to a named official manning the district council court or person appointed as a district judge in terms of Meghalaya Judicial Service Rules 2006. There can be no doubt that district council judge being appointed under said rules of 2006 has been so appointed to take up such matters as district judge ordinarily would. Again, ignoring for time being that at the time the disputed notifications were issued, the code of CRPC had not been wholeheartedly embraced in the state constitutional hierarchy of judicial system, except to the extent of autonomy granted to the district council court was the same here anywhere else in the country, with the district judiciary in its several tiers forming base, High Court exercising superintendence over district judiciary and the Supreme Court at the top of pyramid exercising primacy in all judiciary. Thus, where a notification named a particular judge or referred to the officers of district judge, the conferment of the authority by governor had to be seen to be an officer appointed by governor in that behalf. The fact that since 1970 had not been notified, session division has not been declared in accordance with section 9 of such code. Appointments were made by governor on recommendation of the High Court to the post of designated a district and session judge, and the conferment of authority by governor was either to a person holding such post or generally to that office. There is no basis to appellant's contention that once the authority in terms of 5(1) of 6 rule to the constitution is conferred on a court or an officer, governor has no residuary power. Outright power to carve out the authority already conferred and vest the same in some other court or officer. Indeed, reading such limitation would defy logic and would be anathema to efficient justice delivery system. For example, in a particular matter, judge manning the designated court or named officer conferred the authority may desire to be recused. If the argument put forth by the appellant were to be accepted, would imply that particular matter could not be assigned to any other court or officer, and that would go against the grain of paragraph 5(2) of this rule. It cannot be said that authority to assign particular matter to another remain in some situations, and such authority is not generally available unless the governing provision specifies such. If there is the authority to assign a particular matter to another person or forum, it must be that there is a general authority to carve out a portion of authority already conferred to best to another person with the same. Similarly, there is no limitation on the power of governor in conferring a part of authority, say pertaining to penal code, to a particular code or officer appointed in that behalf, and some other special law to a special code or officer appointed in that behalf. Plain and wide amplitude of paragraph 5 of 6 Civil Constitution cannot be seen to be hedged with such onerous conditions as the authority being required to be conferred on one court or the officer to or the authority once conferred not being capable of being modified in part to carve out the class of matters to be placed before altogether separate court of it. And unsubstantiated factual submission has been made on behalf of them that despite notification the other criminal matters are being tried, like may have been committed with the judicial district court, continue on the same district. Since such factual assertion has been made in the deep and hearing, therefore the argument closed, state has not been. However, in view of the second paragraph, both the notification of 10 December 2005 and earlier notification, trial of serious crime within Revoi district stands superseded and power previously converted to district council court, particular officer can no longer be exercised by extent it has been superseded. The other unremarkable point made by on behalf of the appellant pertains to an indication of source of authority in several notifications referred to herein. While in the ideal situation, the statute and provisions conferring the power and extent of such authority may be quoted while issuing the notification conferring jurisdiction. The fact that power to publish a notification is not indicated or an erroneous provision is quoted would make no difference as long as the power to confer jurisdiction is there. There is no doubt that the power under paragraph 5 of 6 Civil Constitution permitted all notifications referred to here and above to be issued irrespective of whether such authority was indicated in particular notification or the power invoked for such person was erroneously traced back to some rules or whether 1937 rule or subsequent. Finally, 36 Milord, Finally, there is an imaginary ghost that the appellant finds to lurking in second paragraph recent notification issued in the 1973 applicable to all criminal matters in the state. Appellant apprehend that second paragraph is this ingenious provision mischievously included in the relevant notifications to regularize the trial and adjudication of all criminal matters that may have been conducted without jurisdiction as canvassed by the appellant in the present case. That was the argument. Since no irregularity, far less illegality has been found in the conduct of trial in present case, violation of trial conducted need not be. So, in the light of, my lord, the judgment of Honorable Supreme Court in Solan, Melvin Solan Pure, and this matter, my lord, there is nothing left. And what I was praying, my lord, that these trials are languishing and these trials should be concluded.
Yes. So the hearing, anything else, Mr. Mareso?
The only short answer, my lord,
yes.
may give your lordship permission. We are challenging the power of the district session judge. General power of district session judge was exercised by the ADC under the 37 rules. We don't dispute. And the general power of the district session judge under CRPC, that is a general power. If there is no conferment, my lord, district session judge continue to exercise that power. But the moment conferment by the governor under para 5.1 is a special law invoked by the governor that will supersede the entire general provision of law. Therefore, the district session judge has no power to conduct the trial.
In Western Hills.
Yes, that is our case. And second point, my lord, the reference to the Solemn matter. The first thing we moved the petition where learned we refer Solemn judgment, and thereafter it was a hearing over nearly 6-7 months continuously every month. And the conversion case.
Okay.
Even by the special counsel, senior counsel, he placed the judgment of Solemn. Even the court expressed that it is a useless judgment. Because of the last day of hearing, I did not press that point, but that was very much part of
the notification of application to CRPC came out during the
In fact, that was a clear election.
During
the point reached, the argument reached to a point that there was no session division, and therefore the court impliedly expressed that if there is no session division, how you appoint session judges?
That was the real consideration.
That was the real.
How can you appoint if there is no session division?
Yes.
Correct, because they have to come under CRPC.
Right. And
that's correct. Yes.
Realizing that one, governor has issued the application of CRPC. So it's a general direction of the Solemn litigation process only.
That's what usually happens to circumvent, any legal bottleneck. Then some memorandum or notification or legislation brought about, to sidestep it.
Yes. And lastly,
Maladi, even the notification it says that CRPC will be applicable to the courts, not to the areas. Your Lordship will see even section 1.
To the courts are going to conduct the proceedings.
Yes, conduct the proceedings.
Not to this jurisdiction.
So, as soon as you get out of the court,
the only thing is that, the only thing is that
5.3. Paragraph 5.3 also.
Even though the court appreciates the judgment, but then the commercial hands over this benches. That's the only thing. I might personally have a lot of theories and hypotheses, but
lastly,
we'll have to. Yes.
Lastly, my lord, even assuming that, my lord, we did not place refer the Solemn method. Solemn judgment was never part of never placed before the division bench. Even lordship, that will not prevent, my lord.
It has not been challenged in the Supreme Court.
Commercial is coming up in October.
It's been challenged.
Yes. Specifically the notification, because as I said.
By Mr. Ansariya.
Yeah, Mr. Ansariya is leading the matter. Because the notification, we are saying that.
But in his book also, he said something about this notification.
Yes.
He doesn't. He doesn't ascribe to it.
Yes, he consulted me on those issues.
Yes, but I read that part. Yes, I read that part. He doesn't ascribe to it.
Like last week only, he called me and he wanted to.
Interesting, because 5.3 again, whether the notification has been issued legally or not. Because.
But for a time being, as far as these matters are concerned, I think we'll have to wait for. We pass judgment here, but we'll have to wait for the final call.
Yes.
Because it's,
Sooner or later, it will definitely land up in Supreme Court, my lord.
Futile exercise in the sense that the government can just by a tweak of a button can, finish everything. That's what the sixth schedule is so cleverly crafted, the sense that it has given this, this discretionary powers vested on the state government, governor, state government only, to understand situation. As to whether, okay, paragraph 4, we understand, under 5 years, well and good. But then with matters more serious, whether, a certain person deserves, in view because of the ethos, pathos, whatever, being a local judge, whether, he can be conferred these powers. For transportation of life, or so that aspect, that is why that 5(1) is there.
Yes, ma'am.
That is my understanding. That is the Arabian officer is very eminently capable,
Yes.
and he does have power. So confer on him so that he can handle the trials effectively. People are more comfortable in this court.
Yes,
that is why.
That is rationally.
That's the rational nexus
that
they conferred.
Rational.
This conferment actually should be after due deliberation.
Yes,
it's not become mechanical.
This is yes.
And what's happened is mechanical.
Yes, mechanical. The idea behind regulation civil trial is this. This is the idea.
And the entire sixth schedule is very noble. Even for the district council, supposed to have. That's why anti-defection law won't work. Why?
Yes,
because it's supposed to be a partyless system.
Yeah, partyless system where the
people elect a person on his own standing, and they get together and select a committee.
Choose
then
one.
after they choose the member. But after this coming of
the modern now
party
has become
politics, so everything becomes polarized.
No, social media has made the world a global village, my lord. So everything, good, bad, ugly, everything is coming.
Global slum now. Not a village. Yes. Do you want to file any written arguments?
Your Lordship, I have argued. If your Lordship desires, then I can.
Lordship permits, we can.
Yes, you kindly file because I is a bit overburdened now, so I can't immediately.
We'll put
I think other councils also are there.
Yes, Mr. Nokhlav.
Lordship, I endorse whatever.
Of course. That's the point of law, and you understand the limitation that the court has in here. Do appreciating the arguments, but they are other considerations. Yes. October is matter.
Yes.
Final hearing will be.
It will take time, years, my lord. It will take years. Even if the notice is issued, reply is filed, then Supreme Court matter will. Your Lordship is aware.
Because but ultimately, if the Supreme Court holds that the notification is.
So then the trial,
then everything goes.
And if in either way, because that notification will not be held bad in law, because those are under paragraph 2, section 2 of the CRPC only. Issue will be because if the challenge is to the notification, my lord, notification will sustain. Whether the exclusive jurisdiction is there, that issue will be different issue.
No, my lord, in view of 5(3) and then of 12(a). That is also questionable.
12(a) says that the laws made by Parliament or state government will prevail over the laws.
B says that it's only the president
can exempt 12(a).
Can exempt or make applicable.
No, make applicable because we tried in MMDR Act that it is not applicable, but we failed in. We said that in MMDR Act, this was our precise plea in Supreme Court. That was not accepted. That MMDR Act is not applicable. We have got our own laws.
See, there's another very interesting thing here. Sixth schedule came in 1952. 52, June 6, 52, yes. I think. Now there's a bracket, of some laws like which we had argued before. So, for example, employee state insurance is a 1948 legislation, right? It is post-independence, pre-constitutional, pre-sixth schedule. So what is the status of that piece of legislation? But then, and then there was a very interesting case that Shillong, Provident Fund versus Shillong Syndicate. But when the Supreme Court oversimplified by saying constitution came. But even then, those are the things. What is the status of those kind of laws? So the ESI as a council argued that it is post-constitutional, it is pre-constitutional, post-independence.
Yes,
right.
Yes.
But then so it have an application, because it's pre-sixth schedule also, unless by notification is not applicable. So those are the things. Very interesting.
Very interesting.
Yes. You find your submissions?
I have no submission, Your Lord.
Yes, Mr. Wala.
In my point, I've already submitted before this Honorable Court.
When did you submit?
When I think submitted in the month of June, Your Lordship. Submitted in the month of June.
We take all submissions collectively, Mr. Wallang, because it's only the point of law.
No, that's what let me just come to that only, Your Lordship, which is only one point, Your Lordship.
Yes.
Conjuries of notifications issued by the government, Your Lordship. Conjuries, Your Lordship. There is a series of notifications.
Okay.
Yeah. Again and again, they've specifically mentioned about the administration of justice and police in the Khasi and Jaintia Hills regarding the 1937 rules. What I would like to draw your kind attention, only rule 1, Your Lordship. That's very, very important. Extent of rules. The rules extend to the whole of United Khasi Hills District and Jaintia Hills, excluding, Your Lordship, excluding the areas which were known as the Khasis. So on my simple, limited knowledge, Your Lordship, but that means the rules applicable to the entire state of Meghalaya, excluding, which have been mentioned, Your Lordship, excluding the area states before the commencement of the Constitution of India. That's what we're relying every time in this, Your Lordship, on the administration of justice and police. I mean, in short, Your Lordship, 1937 rules.
Yes.
Yes, so that's my humble submission. Why? Because as far as limited knowledge again, Your Lordship, what have been mentioned in Hansarea, I mean, Vijay Hansaria's edition, what's mentioned about there were 25 states, Your Lord, before the commencement of the Constitution of India. What are those states? 15 states belong to the same, Your Lordship.
No, they were 25.
No, I'm talking about excluding the areas.
Steamships.
No, I'm talking about the
They were, now they moved, but that time, there were around 25 steamships. At the time.
Maybe
25 seems.
25.
Maybe 20.
Yes. No. 26, we don't know what 25.
Anyway, I've already mentioned here 25 here. Yeah.
Including the Sardar.
Yes, Sardar and then Bahadar, so on and so forth.
Yes.
You know the points we have already submitted before this court.
Yes.
Yes. So my humble submission, whatever notifications relied upon by the state respondents are excluded to the to the tribal areas. In a very simple interpretation, Your Lordship.
Yes.
Because it's very important, we're relying every time about this. Rules 1937, Your Lordship.
What is the what do you call genesis of the 1937 rules?
Yes. That as far as like a power conferred to the district judge here and this, and I mean so many, in fact, I'm not going through all that. But that's all. But by the basis of the administrative of justice rules 1937, has been conferred.
Okay, I'll note down that. You say that these notifications, none of them are applicable.
Yes. Okay. Rule 1, you know. It's mentioned here.
Where are you reading from?
This is the annexure of the rules of administration.
Affidavit.
Yes, in the counter affidavit.
Reading from which?
Yes, page 21, Your Lordship.
Counter.
Okay. Page 21 of
yes,
the affidavit.
of the counter affidavit.
Yes.
Yeah, annexure R/2, Euro.
Yes.
Yes.
Where reading?
1.
Yes.
Extent of rules I'm talking about.
Yes.
The rules extend to the whole of so and so forth here, Your Lordship.
Yes.
Excluding, I'm putting the word excluding the areas who were known as the Khasi states.
Yes. What about the later instruments are excluded that were
See, I like here. With so many notifications, what is yes, yeah,
Mr. Walang, because many after that, even 950 Khasi import orders there, what happened to areas which were not included? So, and then 6th schedule came. So, you know, that is 37 rules. 37 rules were made under the.
were repealed, in fact, by the Administration of Justice.
You know,
yes.
You know, these 37 rules, it's like a legal fiction because what has happened is that these rules were made under a certain act called Schedule 6 Act 1872.
Yes.
Now the Schedule 6 Act was repealed. The head was cut off, but are left, the limbs are still alive. That's 37.
Rules are alive.
Deriving from 37 rules because it was, by use, because it's with Ratan Singh case,
Ratan Singh.
Nagaland.
That's right. It is part of the.
It'll answer your questions.
It is annexed with the.
Ratan Singh said Nagaland, yes, it went to Supreme Court also. And why these rules are upheld? They said if the Schedule 6 Act has been repealed, then how can the rules survive? Rule-making power is given in an act, right?
Yes.
And rules are made by virtue of an act giving the legislature power to make the rules.
Yes.
Now, the head is gone. It's cut off. Schedule 6 Act is gone. But the limbs are alive.
That is because they have to kill them, like giving them notifications, Your Lordship.
Yes. Those are the limbs, they're still alive.
Only the limbs.
Thank you. The parties submit their short written arguments. Why?
What, 1 week?
10 days.
10 days.
Well, in 10 days, yes. List on so and so. All submissions conclude.